ಅಲ್ಲೇನು ಇದ್ದಿದ್ದಿಲ್ಲ ಅಂತ ಅದನ್ನ
ಅದೆಲ್ಲ ಕೆಳಗೆ ಹೋಗಿದ್ದಲ್ಲ ಅಟೆಂಡ್
ಕೆಳಗೆ ಹೋಗಿ ಅಟೆಂಡ್ ಮಾಡ್ತೀಯಾ? ಯಾಕೆ ಇಲ್ಲೇ ಮಾಡ್ಕೋ, ಎಲ್ಲರೂ ಇಲ್ಲಿ ಮಾಡ್ಬೋದು.
ಡಿಸ್ಟರ್ಬ್ ಆಗುತ್ತೆ.
ಸರಿ.
ಯಾವ ಕೋರ್ಟ್ ಅನ್ನು ನೀವು ಅಟೆಂಡ್ ಮಾಡಿ?
ಸೂರಜ್ ಗೋವಿಂದ ಅಷ್ಟೇ.
ಇವ್ರು ಬಂದದ್ದು ನಂಗೆ ಗೊತ್ತಾಗಬೇಕಲ್ಲ. ಅಂದದ್ದು ಹೊಡೆದಿಲ್ಲ, ಅದಕ್ಕೆ कोर्ट ऑफिसर कोर्ट ऑफिसर कोर्ट ऑफिसर
ಹೇಳಿ.
ಹಾ, ಕೋರ್ಟ್ ಜಡ್ಜ್ ಯಾವಾಗ ಬರ್ತಾರೆ
ಮೇಡಮ್ ಅದು ನಮಗೂ ಗೊತ್ತಿಲ್ಲ.
ಗೊತ್ತಿಲ್ವಾ? ಸರಿ,
ಬಂದಾಗ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅದಕ್ಕೆ ವಿಸಿ ಆನ್ ಮಾಡಿದೀವಿ ನೋಡಿ ವಿಡಿಯೋ.
ಓಹೋ, ನಾನು ಮೂವ್ ಮಾಡಬೇಕಾಗಿದೆ.
ಅವಾಗ ಮೂವ್ ಮಾಡಿ ಬಂದ್ಮೇಲೆ.
ಹಾ ಸರಿ ಆಯ್ತು.
ಓಕೆ ಮೇಡಮ್.
ಓಕೆ. ಕೇಳ್ತಾ ಬಂತಲ್ಲೋ ಮರೆ. ಏ ಪುಟ್ಟು ಕೇಳ್ತಾ ಬಂತು. ಇದೇಗಾರ ಇತ್ತು ಊಟ ಸರ್ತದೆ ಮಾತಾಡಿದಾಗ.
ಅವನ ಕರೀತೇನಪ್ಪ ಮುಗ್ದಪ್ಪ ಕರಿತೀನಿ.
ಮುರಳೀಧರ್ ಅನ್ನೋರು ಫೋನ್ ಮಾಡಿ
ಈ ಪರ ಮುರಳೀಧರ್ ಗೊತ್ತಿಲ್ಲ. ಏನು ಇದೇನು ಅಂತ
ಕೇಳಿಸ್ಕೊತ
ನೋಡು ರಿಸಲ್ಟ್. ಸಾಧ್ಯವಾಗುತ್ತೆ. ನೀವು ವಿಷಯ ಹಾಕೊಂಡೆ ಸರಿ. ತಗೊಳ್ಳಿ. ಮ್ಯೂಟ್ ಇರ್ತದಲ್ಲ ಅದನ್ನು ತೆಗೆದ್ಬಿಡು. ಮ್ಯೂಟ್ ಮಾಡಿರ್ತಲ್ಲ ಓಪನ್ 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 ಸರ್. ಅವನಷ್ಟು ಹೇಳ್ತೇನೆ ಆಗಿಲ್ಲ. ಆಗಿದ್ರೆ ಪಾಪ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ ಅವ್ರು ಅಟೆಂಡ್ ಮಾಡಿ.
ನೋಡ್ರಿ
which has been filed before this court, my lord. Modification because 151 of PC, because some document which has been placed along with the IA. Lord, to establish that, my lord, the respondent wife.
First of all, let me look at the order that's passed by this court.
Please, ma'am.
So you're seeking an IA for modification of an order. Which is the order?
No, the modification of the trial court order itself. Because the administrative order granted, my lord, not by this court. The order which has been sought, my lord, modifications. Because the interim order which has
For
been.
that you file a writ petition.
Yes, yes.
Court, if the
No,
court finds that there is something wrong, court will pass the order. What is this modification of the trial court order?
Oversight, it has been mentioned.
We will hear the matter on the merits of it. What is
Instead of producing the, my lord, the documents, the IA which has been filed.
that we cannot, first of all, I'll dismiss that. What is that order? IA modification of the order of the trial court. Please come to the impugned order. Where is
Impugned
it?
order, kindly see the impugned order, my lord. Page number. Lord, 59 is the, Lord, the order, the Annex G, 58 is that, but 59, my lord. Lord, even trial court, my lord, the trial judge come to the conclusion.
Please.
This, as the petitioner sought, my lord, the third parameter, third IA number 3 from both sides. As per the petitioner sought for interim maintenance of rupees 50,000 per month, and the same is appeared by the opposed by the respondent counsel by stating that respondent is getting a 50,000 salary and he is not in a position to pay the same as his aged old parents depending upon him. The petitioner though stated in the petition that the respondent is earning an income of rupees 1,50,000, but no documents produced supporting by her contentions. Lord, next, respondent filed this salary certificate wherein after reduction now is getting salary of rupees 49,800 rupees, not 40,000, around 50,000. And it also produced his bank statement wherein every month rupees 20,000 is directed towards a heading called BIL and take home salary available in the account is 30,000. Thereafter, looking into the respondent is having age-old parents and he has to take care of himself. Definitely, he requires some amount. But at the time, the respondent being the husband is duty bound to look after his wife petitioner. Therefore, he has spent some amount towards the maintenance of the petitioner. However, the petitioner who is qualified BA in psychology and definitely she can have her own job and she can capable of earning maintenance. Therefore, being the qualified, she should not remain idle without going to the job. Therefore, I am of the considered opinion that awarding maintenance of 10,000 per month towards a basic.
You are appearing for the husband.
No, I am paying for the husband.
So you're not happy with that 10,000 you're not,
No, that's why, my lord, she's working because that is what she has suppressed before the court. That is what, my lord, I have produced the document.
File the document.
No, that is in the IA, my lord. IA. Sorry, my lord, that is wrong. It is in the IA, my lord, where she's getting almost, my lord, kindly see the PF, the deduction itself only shows, my lord, how much she is earning. Her PF details which has been, my lord, taken out. All this, my lord, is not been disclosed by the respondent. Lord, page number, annexure H, it has been page number 6 of the IA, my lord. Lord, kindly see her.
For which month this is?
This is for the, my lord, 31st August 2024, 31st July, then 30th June 2024 itself, my lord.
When is the impugned order passed?
Impugned order passed, my lord. That is on 28/12/23, 22/12/2023. 22/12/2023. Earlier to that, my lord, she is working. But see, suppose, my lord, if this documents, my lord, placed before this court, at least, my lord, if the courts, my lord, summons this document from the, my lord, the PF number which has been already been highlighted, then, my lord, from when she's this is only, my lord, data which has been, my lord, gathered by the petitioner husband that she's working. Earlier to that, my lord, she's working. Kindly see the deduction itself only, my lord, shows.
Objection along with the statement of what my learned.
Already filed. It's already filed. It is here. Objection to the document.
This is I am
For IA,
I am filing. They have produced on the annexure H. I am producing a statement of my accounts and also the document to show that one.
No, let's forget about the other things. What do you say about this document?
You will also kindly see the other. You will also kindly see this document.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದು.
This is the statement of accounts. You will last may kindly turn to
December 23.
page number 23. You will last may kindly.
No, he has filed this document. What did you say in your objections that whether you were working or not?
Well, only from mid to June to August 24 it was work.
Then is it not your duty to bring this to the notice of the court? When did you file the application?
This is 24, my lord. Application is prior to that. The order itself is 22/12/2023, my lord. I joined only in mid 24,
What is the date of order is
23,
23, 22/12/2023,
When did you join?
mid June 24.
June 24.
24. I left job on mid August 24.
Why?
There was harassment, therefore I left the job.
How much you were paid that time?
10,000. You lost my kindly. I'm the document produced by learned friend. For one month 7,000 was paid for June. For July 11,000, 14,000 was paid.
No, it says basic 25,000.
Illa. That the total 35,000
credited
total.
under PF deductions, my lord. That is a
No,
PF
that is not a
deductions.
P. It is not. That is not the deduction. No, deduction is zero. You lost my kindly see the document produced by my learned friend itself. Deduction is all the everything is
No, you
zero.
also admit that as on the date the application is filed, as on the date the order is passed, she is not working.
Lord, that is what.
She is not working.
Lord, she was working. That is what, my lord, we are not able to, my lord, trace out the documents. Lord, subsequently, my lord, because everything is in IDED. Only, my lord, when the, my lord, we have got this information, because the number of the, my lord, husband, which has been given, my lord, tagged in this. Subsequently, when we received the notes, messages, that, my lord, all these PF details, then only, my lord, we are able to search that, my lord, that's why, my lord, we have produced this document. Not only, my lord, this, can, my lord, even she is not even disclosed, even in the, before, when appeared, and the petition is also filed before this court, my lord, to enhancement. Even there also, my lord, they have not mentioned. Kindly see, my lord, in the.
When is the enhancement petition is filed?
Kindly see, my lord.
Please take that WP.
ಅವರು ನಾವು ಜಾಯ್ನ್ ಆಗಿದ್ರು ಮಾರ್ಚ್ 24
Other
March,
next one.
March
What is
30th March 24, my lord.
Lord,
30th
March 24. All in the I did not join that up.
even in
It
the.
is only in the June. You will also.
Before this court also, my lord, the assess and liability which has been filed. There also, they have not disclosed.
23.
When is the assess and liability filed?
Before the trial court, which has been filed, and there also they have not mentioned. Kindly see in the writ petition, my
Why
lord, which
will
has-
they mention
Implement
before the
start
court?
date 26,
The order is
24,
passed
end
in 22. According to them, they're
23, my
working,
lord. This is
23.
23.
They're working from
Look,
24.
No, that is what they said. My lord, that's why the PF, if suppose this number, my lord, if the any the details which has been called by the PF, then, my lord, the truth will come out. Whether from when she is working.
Lord, should I kindly see?
See, my lord, normally, nobody will disclose that from when they are working.
Document
Because
produced
only
by
now,
learned
because
friend.
when I
Deduction
produce,
is-
sorry, when I produce this document,
Look at the document. It
when I
speaks
produce this
about-
document, sorry.
It speaks about 23, 24. You say that you are working from 24,
No, 23. You Lord, should I kindly see my document? You Lord, should I kindly annex it.
not your document. Do you dispute
no.
this document?
There, the date of
Do you dispute this document?
Yes.
Page 1A, which is filed by him.
that is the same document I have produced. Your date of appointment is there. Date of termination is there. Your Lord, should I kindly turn to page number 20.
Showing the joining date is 3/10/2022.
No. That is, your Lord, should I
But
kindly
then you
turn.
are denying it, that then we have to, I have
Yeah,
to record that.
I am denying that document. Your Lord, should I kindly page number
This is
23.
the employer, we'll call for the record.
Your
from
Lord,
them.
should I kindly, I have produced the document where there is a reference to the date of appointment and date of the end date. You will apply,
Where
kindly
shall
have
you-
it to page
where
number
shall you
20.
record these documents?
Lord, this is, Lord, where.
Page
because-
number 23, your Lord, should I kindly have it.
Sir.
It is appointment dated 26/24, end dated is 28/24.
That I understand what your document is saying. What is this document? Do you deny?
Same
it?
document, the same document, the date of appointment is referred to in page number 23.
Joining date 3/10/2022, that's what is referred in this
No,
document.
your Lord,
ಎಲ್ಲಿದೆ?
same.
Which document?
New document only.
ಇಲ್ಲ.
Which document? The document is not.
That is filed by him.
ಯಾವ ಸರ್ ಅದು?
You have not given them the document?
Copy given.
ಇದು ಒಂದೇ annexure is ಒಂದೇ
ಅದೇ,
ಕೊಟ್ಟಿರೋದು.
ಒಂದೇ,
This is-
only one.
this
Copy
is-
given long back.
ಇಲ್ಲ, ಆ ಡೇಟ್ ಇಲ್ಲ ಸರ್ ಇದರಲ್ಲಿ. ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಕೊಡ್ತಿರೋದು?
ಇದೆ.
This document, this is the only document produced, that connected, I have produced the document.
This is what it is before the court.
ಸರ್ ಎಲ್ಲಿ
ಆ document
2024 and 25 ಅಂತ ಇದೆ ನೋಡಿ 24 and 25.
How can you not give the documents to the
No,
other
no,
side?
that I've given all
So
the
this is the only document which
not
was
our
given
document.
along with the application.
That is not our document, it is their document.
1 year is their document.
Yes, yes.
Ravi Shankar, you filed it.
One item.
That is the petitioner joint document ಅದು.
That is my.
Our
document.
document, our
It is my
document.
document.
Husband
That is
working
the-
with me.
The date of appointment of the petitioner.
Oh, your document, please take it. Document 1A.
Which petition?
Statement of objection.
Statement of objection earlier. ಒಂದು ಇದು. ಇಲ್ಲಿ ಮಣಿಕಂಠ. He is the annexure.
Your lordship, 1A
1A, it is our
is
document.
the document belonging to the petitioner.
Our document, it is
Our document, he has the joining date.
Not able to understand what is this. The respondent herein producing the statement of account of the, it may be taken on
Two
record.
connected matter. Petitioner from enhancement.
That is your.
That's my
your-
document. He has produced to establish that I am working, I am earning this much. So it is my document they produced.
And then what is your, the document which you have
Document which I
produced?
placed, my lord, on annexure A, my lord, along with IA I produced, annexure H, my lord.
Kind of. Where are these
That PF document, my lord. No,
Ask him
that
when
is
he
for
says the
direction which has been filed, that is wrongly mentioned.
ಅವ್ರು ಇದೆ ಹೇಳ್ತಿದ್ದಾರೆ. ಅವ್ರನ್ನ ಹೇಳಕ್ ಬರ್ತಿಲ್ಲ. 17(6) ಅಲ್ಲಿ ಹಾಕಿದಾರಲ್ಲ ಈ ಡಾಕ್ಯುಮೆಂಟ್. 17(6)25 ಅಲ್ಲ. ಇದ್ರಲ್ಲಿ ಅವರು ಜಾಯ್ನಿಂಗ್ ಡೇಟ್ ನನ್ನ ಹತ್ರ ಇದೆ. ಯಾಕಂದ್ರೆ ನಾನು ಜೂನಲ್ಲಿ ಕೆಲಸ.
Annual tax statement.
ಜುಲೈ ಸ್ಯಾಲರಿ ಕೊಟ್ಟರು.
TDS which has been deducted.
Details not detected.
Now, kindly see because it's an, the entire, the tax, PAN number, other things, details, which belongs to the wife.
What it says about
Lord, kindly
August,
see,
November.
the amount which has been, because the TDS which has been deducted, the uploaded in the portal of the PF. So where 30th June, 37th July and 31st August, where she is working and she is getting the
It is 2024.
True, my lord, my contentions even before the trial court, that earlier to filing the making.
That's your burden. That is the burden lies on the husband to prove that. No, you cannot assume and presume something, and you also can't expect the court to assume it.
No, that's right, my lord, this document was not available on particular time, my lord.
Even this document also does not show that as on that day she is working. This only shows subsequent to filing of it. Now they take a stand that only she worked for a limited period. So for that, what we can only assume is that she is capable of earning and she can get a job.
Please, my lord, here,
That's what it is.
sorry, respective submission, my respective, my lord, PF number is not, my lord, easily accessible to everybody. My lord, when she has to, my lord, appointment and other
But
things.
not
the
before this
Employer, my lord, has to, my lord, the employer, my lord, until unless the employer, my lord, now the details which has been, my lord, taken. Lord,
So what is your salary?
Lord, my salary is 49,000, Lord, that is has been, my lord,
What is
calculated.
that you are paying?
Lord,
Some-
now, nothing is, my lord, we are not.
He has not paid anything.
No, no. You have shown something,
Yes,
20
my
or
lord,
30,000.
parents and, my lord, that loan and everything is going on, my
What
lord.
is that loan?
That 20,000, which may not taken for the marriage purpose. Marriage purpose, because 2020 only the marriage which has been taken place. So on that particular time where I have taken for loan, that my lord I am repaying. Now, my lord.
So what is remaining with you
Now,
is 30,000.
That, Lord, 30,000. So, my lord, old age parents are there. Lord, only I am the persons to, my lord, take care. They are all, my lord, old age elements, they are suffering, my lord, require at least, my lord, 15,000 to, my lord, 20,000 for, even she is not in a position to, my lord, bedridden.
So if
She's
the
a
wife
bedridden.
if the wife is with you, what would have done?
My lord, definitely, my lord, she was also, my lord, that is what the promise which has been given, that she will also help in future that working. Lord, that, my lord, she wanted to lead a lavish life, because even where I am working as a, my lord, as an agent, that is also, I quit the
How-
job.
What was she,
Psychological BS.
what was her salary?
Now he is drawing
Not
70,000.
his salary, your salary.
Ah.
15,000.
Your salary.
Your salary was 17,000 as on, for 1 month. She worked only for mid June to 20th June to 24 to August 2024.
So she is capable of earning, she can get a job and she can earn 20,000 a month. 17 or 20,000 a month.
She can earn. If she got the job, then only.
Please come.
Your Lordship may kindly see the statement of account. Your Lordship has directed to file an affidavit wherein he was drawing 69,000. Where fixed deposit was made in the name of the mother. That is mother of
How much
the.
is salary as per the statement of assets?
Huh?
How much is his salary?
Salary is 70,000, my lord. Other than that, he is working. Your Lordship may kindly see the document I have produced. Income tax returns, your Lordship may kindly see.
That is before marriage, my lord, not after
It is
marriage.
not.
Before marriage, all these things before marriage.
Page number 6, your Lordship.
Refer to the documents which can be looked into by the court as per the judgment of Rajneesh versus Neha. What are the documents that are to be filed?
I have produced the from the month of payslip of 23 or 23. Thereafter, I have produced the income tax returns filed by him, wherein he has declared the income
Yes.
from the salary other than salary 3,50,000. He has declared. Your Lordship, I have produced the document in this petition itself.
Where is that page number?
Page number.
Additional
I have produced the document subsequent.
No, the problem is when you are filing, anybody is filing any document. Without
is-
a page number to that, how can the court, there should be a running numbers.
Yeah,
One after the other.
I have with page number I have produced, and on that basis, your Lordship has directed him to file an affidavit stating how so much of deposit can be.
What both of you have to understand is there is a lot of confusion for the court to look at the documents. Who has filed who, what, where is the document, which page number it is. Nothing I am able to see.
Your Lordship may kindly have next, I will make a synopsis and file it.
This is matter next week. Unnecessarily, court-
Lord, there, my lord, they are pressing for, my lord, execution. Lord, they are pressing for maintenance, my lord, which ordered by.
Yes, next.
Even the stay is not there, my lord, that's why.
We'll see.
You know, your Lordship, my lord, earlier occasion, only to dispose of the matter was
But
heading.
what to do? You people are not cooperating for the disposal. No documents, no numbers, nothing.
No, that is there.
Unnecessarily, half an hour time is wasted without any work. What about that party in person's case? Where is she?
Passed over.
Belongs for the petitioner. Sorry, ma'am.
Party in person.
Petitioner, ma'am.
I am the petitioner.
Passover matter, where is
Yes,
she?
sir. Passed over Abraham. Dina Abraham. Where she is?
She's not outside.
Dina.
Call the next matter.
Here number 9.
Serial number 9, your ladyship. We are before your ladyship for compliance of the order dated 10/6.
My lord, is this WP 5493 or which WP, lord? Because in WP 5493, we are the petitioners, my lord. So may I know which case the court is hearing as of now?
Court will hear everything starting from 34901, what which
I'm
is
the-
listed in
Correct, your ladyship.
the cause list.
Obliged.
And before
Yes,
both of you start your argument,
yes,
I do not want any kind of interference when one counsel is arguing.
absolutely.
What I do is, if any counsel unnecessarily argues, I'll dismiss the case with exemplary cause imposed on the advocate, not on the party. And whatever I ask, please answer to the queries, then make your submissions. Yes, 34901.
Yes. This is a challenge to the impugned order of the Honorable Principal Family Court.
Page number,
Yes, your ladyship. The impugned order is page number 30.
30.
30.
Yes, please read the order.
And the operate, yeah, I'll read, your ladyship. The order starts from page number 31. May I? This petition is filed under section 24 of the CPC to transfer GNWC number 141 pending on the file of the third additional principal family court. In the petition, the petitioner has made several grounds for request for transfer. In para 12, 1 to para 46, the petitioner has mentioned the day-to-day proceedings and what happened during those days.
This petition is filed by whom?
By the husband.
Seeking transfer.
Yes, Your Ladyship, before the Honorable Principal Judge. Along with the petition, during the hearing, the learned advocate for the petitioner has produced documents and additional documents. Considering the urgency of the matter, notice of this petition is issued through email to the respondent who is representing GNWC as a party in person. That time she was party in person, the wife. And also by hand to the petitioner, permission to serve the notice through email. Now, Your Ladyship, this office has received a memo through forward posted by the respondent with reference to the petition in the said memo and expressed her inability to attend the court. And she has filed miscellaneous 34 and 35 for transfer of GNWC and MC from the third additional to the other court. Those two miscellaneous petitions filed under this are dismissed as withdrawn by the present respondent. So, Ladyship, I purposely read this. Yes. From going through the documents along with the petitioner, it is clear that on 23/4/19 in WP 1821, order was passed by the Honorable High Court of Karnataka by issuing direction to the family court to decide the application filed by the petitioner afresh by a speaking order within 6 months from the date of receipt of the certified copy. The respondent wife has filed transfer petition 1752 of 22 before the Honorable Supreme Court. The said petition came to be disposed of by observing that they are not inclined to entertain the present petition as the proceedings in the petition are at an advanced stage and evidence has already commenced, and liberty is given to the present respondent, that is wife, to appear virtually. On 23rd September, in two petitions, namely WP 5493, which is also here, clubbed with 9057, order was passed by the Honorable High Court of Karnataka and direction is issued to the third additional principal family judge, which reads as under. The learned judge of the court below is requested to try to dispose of the pending matters within an outer limit of 6 months, consistent with the observations made by this court in WP number 14769 of 23 between Rajiv versus Deepa, disposed of on 26/7. Those petitions.
So this application is rejected.
Correct. But the only reason why it's rejected is this reason, Your Ladyship, which I just read. But my grievance is when the wife filed the petition for transfer, her petition was kept pending for 11 months. And the mandamus of this honorable court.
Why the petition should be transferred is the first question.
Correct. Your Ladyship, the reason was browbeating of the judge, as we demonstrated last time with respect to the.
No, as of now, all those things will not remain as it is.
Please.
Because the judges are transferred. So
that is why I was filing for withdrawal, because my grounds become
infractions. We will dismiss it as
withdrawal. I had already filed the memo on the last date itself.
May I submit notes? Before this honorable court dismisses this petition, we had filed an IA seeking contempt proceedings to be initiated against the petitioner because he had made a few scandalous remarks about the sitting judge on the face of this honorable court, please, my lords. I would be grateful if this honorable court just goes through that one application, please, my lords.
Where is that?
My lords, the para 25 of the writ petition, please, my lords. Has my lord got it, my lords?
Yes.
My lords, para 25. The petitioner, that is the husband.
Para 25.
Yes, please, my lords.
Page number?
My lords, it is his petition only, my lords. Here, my lords, the petitioner, that is husband here, states that the Honorable Principal Family Court Judge erred in becoming a part of the browbeating tactics of the respondent wife in defeating the mandamus stated supra, in fact, aiding her extortion.
What do you mean by this, Mr. Counsel?
I'll explain, Your Ladyship. When the petition was kept pending for 11 months, Her Ladyship, the principal judge, asked for a report subsequent to the complaint to the Registrar Vigilance from the third additional. And we complained that there is a mandamus, it has to be expedited. Then third additional started the proceedings. Nevertheless, after that report was given to the Honorable Principal Judge, she has recorded in the order sheet that the final offer of the wife is 20 lakhs odd, which again she went back on. So the entire endeavor was from the Supreme Court till then on the maintenance amount. And that is why we say we are alleging it is bro beating, because I'm covered by the exception under the Contempt of Courts Act, Section 13, because it's borne
No,
out.
but don't go into all
Please,
those
okay.
technicalities.
My reason.
What are these statements
My
against the
reason.
judges?
My
Can
reason.
they work? Can they perform their duty? Something which is in favor of you, it's fine. If it is
No,
not
no.
against you, then the judge is
no,
wrong.
We have never complained. What we are,
No, there is a manner to, you know, how the pleading should be in a legal proceedings. And what kind of allegations you're making in this?
because it's from the judicial record. 11 months she kept.
What you
pending.
understand cannot be the intention of the judge. It's very unfortunate. We do not expect you to make these kind of pleadings because you are before the High Court. You make something about the district judge, go to the Supreme Court and make something against the High Court judges. That's not the way. We do not entertain. You are an officer of the court. You have every responsibility to be fair to the court. And if you say that something is not right, there is a way to express it. Not this way. Please stop these kind of pleadings.
That is why when we were kept pending
Please
for
don't
11
do
months,
this.
for 11
Please
months,
come.
and ours was disposed of in
and-
30 days.
Kindly see the objections he has filed. There is no remorse, my lords. He doesn't
Anyhow,
feel
now
sorry.
the thing is more now it is becoming more of an academic this thing. Court has lot of work and people are in need of justice. We'll
proper
not go further into this.
Yes, ma'am.
Yes, come. The present writ petition is filed. Seeking the following prayer. Extract the prayer. The court or the petitioner husband filed miscellaneous number 121 of 2024 under section 24 of the Civil Procedure Code to transfer JNWC number 141 of 2017 pending on the file of the third additional principal judge, Family Court, Bangalore. The court had dismissed the said application. While dismissing the application, the court has observed that there is a specific direction to the third additional principal judge, Family Court, Bangalore, as a High Court in its judicial proceedings, has issued direction to third additional principal judge, Family Court, Bangalore, to dispose of the pending matters within an outer limit of 6 months. The power of the court under section 24 CPC is an administrative power. Therefore, there is no need for considering the merits of the case, as there is specific direction to dispose of the matter by the third additional principal judge, Family Court, Bangalore. Under section 24 of the CPC, the court cannot withdraw the case from the file of the third additional principal judge, either to keep for itself or transfer to any other court, and accordingly dismiss the application considering the direction issued by this court in WP number 5493 of 2022 and WP number 9056 of 2022. Where is the IA for this? Where is that application?
No, it is dated 17/3/2025.
Page number.
No, this is IA 1 of 2025 to initiate contempt proceedings.
Not IA number 1 of 25. Your IA for this transfer.
Transfer, yes, lady. That is, the petition for transfer is at page number 50. We had to file a petition under section 20.
The
Memorandum of petition
Yes.
under section 20.
The miscellaneous petition is filed
Annexure C.
seeking transfer. What has been stated in the said application is that It is stated that from 26/4/2007 till date, the parties are referred to as wife and husband. The wife has committed contempt of the third additional family court judge in JNWC number 141 of 2017 by writing multiple letters addressed directly to the presiding officer, Registrar General, Governor of Karnataka, Chief Minister of Karnataka, and other government and judicial officers and authorities, despite mandamus of the Honorable High Court dated 23/4/2019, that the wife has violated the injunction warrant issued against her by the third additional family court judge. And it is stated that the wife is continuously committing fraud on court and contempt of court.
May I just interject here because your ladyship is taking up. We have also filed IA number 2 of 25 with the same contentions because
This is your petition.
it is
I'm
my
looking at.
petition in that IA number 2. The reason your ladyship is aware of your own order with circulars to the family court that when there is an expiry of a mandamus, they should write to this honorable court seeking extension, which has been made mandatory.
If somebody has not written it,
Yes.
you cannot, you can't
I-
allege
yes, you're right, you're
things
right.
on the
I bow
officer.
down, I bow
That is what for all that I only I'm
I bow down.
looking
So,
at it.
so please refer.
If the officer has not done it,
Yes.
you can ask, you can come to the court. There is a mechanism for that.
Yes, I
That
think-
is not, saying that, the judge is doing something. By all these acts, literally, the clients of, or parties, clients or advocates are not letting the officers do their work.
So your ladyship, in IA number 2, we have also asked for initiation of contempt against the respondent wife because of these reasons. And that is comprehensive.
I am not looking at either her IA or your IA.
Please, please,
I am looking at
Yes.
what is the order, what is your affidavit or that your application.
Yes.
And they have also referred to the transfer petition that was filed by the wife and the mandamus that is issued in WP number 9057 of 2022. And it is stated that on 15/12/2023, advocate for the wife had sought time It is stated at paragraph number at ground number 12 that on 15/12/2023, advocate for respondent Asha Devi filed wakalat and prayed time for cross-examination, stating she needs to collect certified copies and go through them. Petitioner husband filed application to appoint court commissioner to avoid procrastination of proceedings by respondent and her advocate. The procrastination, dilatory tactics, fraud on court, contempt, mockery of judicial process, and browbeating of the third additional principal family judge by the wife and her advocate are judicially noticeable from the below facts. And at paragraph number 1, the petitioner has narrated how many there? 44 or 54?
Your ladyship, page number?
Page 56.
Yes.
So how many are there? How many grounds?
Yes, your ladyship. In the petition before the principal judge, about 15 grounds.
50,
15, sorry.
not 15.
Yeah, I'm sorry, your ladyship, please.
Starting from 12.
Yes, 46.
46 grounds were raised or stated the facts which has about the proceedings that that took place before the court. In all these grounds, it is how, in spite of an order passed, a mandamus that is issued by the court, how the judge has not disposed of the matter. And finally, on these grounds, the petitioner wants the petition to be transferred from the third additional to the other court. Then when it comes to the grounds that are stated by before this court, that paragraph in ground number 24, it is stated that,
I have 49 grounds here.
no, in the grounds here, it is stated that the impugned order is bad in law and it does not consider the judicial fact that the third additional principal family court judge did not take any steps, measures to either implement the mandamus mentioned or seek for an extension from this court, from the High Court. And further, at ground number 25, it is stated that, inverted commas, Honorable Principal Family Court Judge, had in becoming a part of the browbeating tactics of the respondent in defeating the mandamus stated supra, in fact, aiding her extortion divorce ranging from 2.55 crores to 20 lakhs as judicially noticeable from the order sheets that are filed in annexure
F.
Land counsel appearing for the petitioner submits that when there is a mandamus that's issued by this court and directing the family court to dispose of the matter, in spite of the same, the court has not disposed of the matter. As such, it made them to go before the principal judge seeking transfer of the matter. It is submitted that the principal judge, without considering all these facts, and that the judge has failed to implement the orders of the court or seek extension of the time, had dismissed the application. Land counsel appearing for the respondent wife submits that wife has drawn the attention of the court to the ground number 25, which is raised by the petitioner, and in support of this petition, and submits that it is nothing but it amounts to the contempt of court, and unnecessary allegations are made against the judicial officer. As such, she has filed IA number 1 of 25. Land counsel has filed, you have filed IA number 2 of 25.
I filed my objections and I filed IA number
Objections
2.
to IA number 1 of 25 and also filed 2 of 25 for
Initiating contempt against the respondent wife.
initiating contempt against the respondent. Next part. Having heard the counsels on either side, what is the material on record? The manner in which both the parties are pursuing the litigation and how they are advised is also very unfortunate. If an order is passed by the court, orders of the court are not complied with, there is a procedure known to law. Just because in a time-bound manner an order that is passed by the court is not implemented, the petitioner cannot make these kind of allegations against a judicial officer. The family courts at Bangalore are burdened with thousands of, each court is having thousands of cases, and with these kind of litigants who are fighting for the sake of litigation, one application after the other, making allegations against each other, and by filing these kind of applications, in a way they are trying to, it affects the morale of the judges, and morale of the judges. This MC is filed in the year 2024.
Your Ladyship, this is arising out of GNWC.
GNWC is filed in the year
2017.
GNWC is filed in the year 2017. There are several proceedings before this court, before the Honorable Apex Court, and both the wife and husband are fighting tooth and nail And it is, the both of them have to restrict, they can fight against each other, but in that process, they cannot make these kind of allegations against the judicial officers. And this court cannot appreciate this kind of a conduct from either of the parties. And particularly making these kind of pleadings before the court, all the more, it cannot be appreciated. Whatever is the grievance of the party, when while drafting the pleadings or filing and placing their case before the court, the party should have a restraint, and the advocate should also advise the party properly that that everything and whatever that happens and whatever they feel like shouldn't be reflected in the pleadings. And then coming to the transfer, on these kind of grounds, transfer petitions cannot be any orders can be no orders can be passed on these kind of petitions. And the principal judge, family court, was right in considering and dismissing the petition, and this court finds no reasons to interfere, accordingly dismissed. Next matter,
One.
take WP in 5493.
Yes.
I'm the petitioner there.
Yes.
My lords, I may be permitted to come there, my lords.
It's okay, how does it matter?
Okay, my
I'm
lords.
already ready.
Fine.
with my-
Yes.
My lords, may I make my submission first, please, my lords?
I want, there is a, in my
Direction.
court, there is a procedure to make submissions. First, I will look at the impugned order,
Yes.
then you can make your submissions.
Please, my lords.
Where is the impugned order?
But just before this, my lords, may I?
I will look at the impugned order, then only I will hear any other facts. I don't want any facts which are unconnected with the order. Where is page number?
My lords, the impugned order is at annexure H. I'm sorry, my lord, one
Annexure
second.
G, page 59
Annexure G,
as
my
per
lords.
their petition.
Annexure G.
Page?
59. 59 it starts, your ladyship. That is the impugned order, dated 11th November 2019.
That's in IA number 24.
That's on IA 8, my lords.
8 and 9, 3 IEs combined. It's a common order, 2, 8 and 9.
IA 2, IA 8 and IA 9, please, my lords.
So which is, no, you're agreed against which order? IA number?
My lords, the very simple thing here is, my lords, IA 2 was filed by the petitioner seeking interim custody of the child, and orders were passed on 19/4/2018, rejecting the application by the petitioner, my lords. With regard to that, he comes to the High Court in WP 18121 of 2018. The complete details, my lords, will find in page number 42, annexure D, please, my lords.
For brevity, may we address as
May
husband
I
and
submit,
wife?
please? Annexure D, my lords, page 42 is the order dated 2/8/2019 on IA 2, where the
Please come
complete.
to your prayer so that I can understand better. What is that it is impugned here?
My lords, when IA 2 19/4/18 was rejected, the petitioner comes before the Honorable High Court in a WP 181 of 21 of 18 and ensures that the case is remitted back to be heard afresh, my lords. The court again hears the matter afresh and passes a detailed order on 2/8/2019, my lords. That is what my lords will find in annexure D. But suppressing this order, my lords, the petitioner files IA 8, which my lords will find at annexure E,
IA number 2 is filed by the father or the mother.
father, my lords.
What is the relief that is sought in IA number 2?
Interim custody, my lords.
Interim custody.
That is at annexure C, my lords.
Then
Dated 26/4.
IA number 8. What is the, who has filed IA number 8?
My lords,
Father or mother?
the father again.
What is that relief he sought?
My lords, here what happens, just one, you have to just go back, my lords. The order was passed finally on IA 2 after the mandamus from the Honorable High Court. The
That I
order
can
was passed on
understand.
2/8/19,
That I
my
know
lords.
further. First tell me, what is IA number 8?
My lords, he files IA number 8 on 21/10/2019 seeking a direction from the court that the child should not be removed from the jurisdiction of the Bangalore
Yes.
court. But my lords,
1 minute, 1
yes,
minute. Then what is I number 9?
my lords, IA number 9,
Who filed it?
Father,
he only,
Yes.
for production of the
He only
child
can, my
on
lords.
2 level.
to produce the child on 28/10, that is back to back, my lords.
On 2/12/2019. So now what the court did, IA2 filed by the petitioner seeking visitation right is kept in abeyance till the production of the child before the court.
My lords, that is what we are challenging, my lords. It doesn't happen that way, my lords. May I just submit, please, my lords? On the order dated 2/8/2019, my lords, Annexure D, please, my lords.
Page numbers, please refer to the page number.
42, please, my lords.
Yes.
Annexure D, my lords, order dated 2/8/2019. Here, my lords, it's a very detailed order where the honorable court has recorded that IA2 that was filed by the father seeking interim custody for the girl child in the
So this
weekend.
order is dated 2nd August
Yes, my
2019.
lords.
Impugned order is dated?
11/11/2019, my lords.
Hmm. What is the order passed in I number 19?
My lords, in this particular order, my lords, if my lords can come to page number 45, my lords, the details that the third line, the said order challenged by the petitioner before the Honorable High Court of Karnataka in WP 18121 of 2018. The said court was pleased to set aside the order on the ground that it is evident that the family court has treated the contents of the letter in the conspicuous truth and has proceeded to deal with the application filed by the petitioner merits on the basis of the letter written by the respondent. Hence, the court is supposed to decide an issue pending before it on the basis of pleadings of the parties and on the basis of submissions.
No, this
So, my
order
lords,
in I
after
number
this-
2.
After this, my lords, 1 second, my lords, kindly come to, this is what is very important, my lords, page number 47, where the court has come to the conclusion that a petition filed, page number 47 and 48, which the petitioner filed, the father, husband filed in Malda, seeking custody of the child. There, the jurisdictional police that gives a report. Based on that, that court passes an order that the minor child should be handed over to the mother. This order is quoted by the family court in this particular order, my lords, very clearly recording that on the date of filing, page number 49, line 6, hence, as on the date of filing of the application, the child was not residing within the jurisdiction of this honorable court, and the child is below the age of thing. And the only little change in
Have you filed an application questioning the jurisdiction of the court?
No.
my lords,
Yes, why did I asked her?
my lords,
You, just one answer to that. Have you filed an application questioning the jurisdiction of the court?
my lords, we were satisfied with this order, my lords. When he has filed for the interim custody and the court has said that the father can visit the child in Malda. Kindly see the last para, my lords.
That I understand.
Yes, my lords.
You have surrendered to the jurisdiction of this court and you have been contesting the matter here.
My lords, that is what has happened, my lords. See, once this order has been passed, please see IA 8, the date, my lords, 21/10. He comes before the court on the once the presiding officer changes and he suppresses the fact that IA 2 has already been disposed. You kindly see the pleading, my lords, page number, para number 4, the very next one.
Where, what is the next one?
IA 8, my lords, Annexure E, please, my lords. Page number 53, my lords. Here, he says, I state that the same shall be demonstrated by adducing unimpeachable evidence.
Where is that affidavit in I number 2? I number 2 affidavit.
Page 38.
Page?
38 onwards, your ladyship. That is the IA, annexure
The
C.
IA to what he
Yes,
has
annexure
filed.
C. And the affidavit is at page number 40.
This is objection. Page 25 is objection.
She has not filed objections to this IA. Instead of
Lords,
that,
the objections have, whatever has been done, my lords, end of the day, the order on IA 2 dated 2/8/2019 was, the application was disposed of, my lords. This fact has been suppressed by the petitioner and he, my lords, please.
I think I'm not competent to hear this case. I'm not able to understand anything. I think I'll let this matter go before some other court. This matters
your ladyship,
before
may,
for some
may-
other court
may-
after obtaining the necessary orders from the Honorable Chief Justice.
may I make a request then? Why?
Yes.
Because
Because I can't waste time like this.
Yes, the germane,
next.
the germane matter
The
is,
thing is very simple, my lords. He has suppressed that the IA2 is already disposed of, my lords.
Yes,
He
next.
only says that WP
Call the
order
next
is.
matter.
if this
Sorry.
matter can be posted for special orders to be listed before the honorable division bench where the contempt petition is pending. This is the germane
That
matter.
you cannot ask. Let the Chief Justice take a call. Yes, next.
Obliged, obliged.
Yes, my lords.
May I assist the court in 9057? It is infructuous, that may be. Yes, even the bench was pointing out this on
Even in that hotel bill.
Which one?
WP number 9057. It was for interim custody during summer vacation, which is infructuous.
Yes, next.
The hotel bills have not been paid for that, my
Bill
lords.
number
Yes,
10,
next.
Grateful.
Obliged.
so now open.
My lord, my lord, with your lordship's kind leave, I was not able to move, my lord, in the beginning because it was not audible. My lord, my colleague who was in charge was required to go out of station, my lord. Therefore, this has been intimated to the other council also. It may
Yes.
be posted on 7 or any other date convenient to your lordship.
Matter on 15th.
Bill number 11,
On behalf of petitioner wife in this matters, my lords, I'm challenging Annexure A, which is at page number 81. That is on orders on IA, which has been rejected, my lords. A small background about this case.
So this is filed by the,
Petitioner wife.
for maintenance.
Petitioner wife, who is the respondent in the trial
He's
court.
rejected.
Sorry, ma'am?
He's rejected
IA has been rejected, my lords.
for interim maintenance.
Yes, ma'am.
Not-
Not intermaintenance, my lords. I had asked for call records and hotel records.
What is the MC for?
The husband files a divorce petition, my lords. In return, I also file a counterclaim asking for the divorce on the grounds of adultery. In support of my case, I filed
Husband's ground is,
cruelty.
come to the impugned order.
My lords, it begins at page number 81.
Yes.
The actual portion, my lords, I request my lords to look into page number 88. Fourth line from last. my
From paragraph 10, we'll read.
Yes, my lords. So having heard both parties, the court has given anxious consideration to the materials on record. It is forthcoming from the averments of the affidavit annexed to the present application that the respondent intends to summon the call details of petitioner and Raksha SV in order to prove adultery committed by the petitioner and Raksha SV, also known as Raksha Vijay Kumar. It is pertinent to note that the relief sought by the petitioner is also dissolution of marriage with the respondent. The respondent has also sought the relief of dissolution of the marriage dated 6/7/12 and registered on 28/5/2013 along with permanent alimony by way of counterclaim. Considering the relief sought by both the parties, my learned predecessor in office, vide order dated 16/3/2023, conciliated parties and observed that the dispute lies between the parties in respect of the quantum of maintenance to the respondent and her child. Therefore, the parties were directed to leave their evidence in respect of maintenance. Both the petitioner and respondent have affixed their signatures to the order consenting to lead evidence only in respect to maintenance or permanent alimony to the respondent and her child. In view of the above observations of this court and the light of the same
Where
relief
is
sought
that
by
order consenting to lead?
my lords, there is an extract at page number 108, my lords. I have not furnished the order sheet.
So both the parties have agreed that they will lead evidence only with regard to
True, my lords.
maintenance.
And my
So
IA
why-
came to,
so why do you require all that?
my lords, on the same order, my IA came to be rejected. But subsequent to that, the counsel for respondent in the trial court, petitioner in the trial court, files a memo requesting the court to consider the matter only on the merits. And the memo came to be allowed, my lords, even after we filed our
Where is that?
objections. It is at page number 106, my lord. My lords, if you may go to 113, my lords, memo dated 18/12/2024 filed on behalf of the petitioner is allowed.
From any angle, this court opined that just and proper to pass a judgment on merits.
In
by
fact-
considering the evidence led by both the parties, as the court proceeds to pass the following order. Where is that memo?
My lords, memo is at page number
Submitted to the petition.
101, my lords. In fact, I've also filed another writ petition
This
challenge,
order is dated.
my lords.
This order is dated.
Memo.
This memo order,
Memo order dated is 25/1/2025, my lords.
25/1.
2025.
Now what is this order?
Rejecting on
Date of this order, impugned order.
impugned order, my lords. 4/12/2024.
4,
12/2024.
As on that day, this order was right.
My lords, the conciliation happens on 16/3/2023.
As on that day, on 4/12/2024, this order was right. Now, when the court is hearing on the merits of it, this is not, the court has
So
never.
just after 4 days from passing the order on the IA, he files a memo, my lords.
No, you want it on the merits of it or not?
My lords, either ways, my lords, but if it is going on the merits, this IA has to be considered, is my humble full
So
submission, my
what the
lords.
court said, court has not passed any order on the merits of your IA. Court only said, in the light of the fact that both have agreed that it will be decided only on maintenance, it was dismissed. As on that day the order was passed, there is nothing wrong. What this court can do is, like, I will leave this open to file an application and then court will decide.
My lords, in fact, challenging that memo, I've also filed another writ petition in WP 2686 of,
Notice
if both
is
the
served.
petitions can be heard together, it will.
Notice is served.
Sorry,
Notice is served in that.
not in this petition. In that petition, the notice is served.
Yes, list along with so and so.
Number 12. Count Nandagopal.
For the petitioners.
Your Lordship, I am not seeking any interim stay or any interim prayer in this. I am for the petitioner husband.
Notice. Next. Notice. We have served the papers on the caveator.
I am the caveator, Swami. I am only the caveator in this thing. If caveat may be seen, I am the caveator in this and I am the only one who has filed this petition.
Yes, notice the response.
Notice may be served to the trial court counsels also.
Same hand summons on the council appearing to the
Then number 13.
Much obliged.
13. Yes, Naveen Kumar.
Lord, the petitioner is the husband, my lords. Lord, before the trial court, the order is challenged.
Appear for
Annexure
exponent.
A, my lord. Lord, the clubbing application was filed by the respondent
Where
before
is
the trial
impugned
court.
order?
Lord,
Impugned order.
impugned order at page number, annexure A, my lord.
20.
Page number 20, my lord.
Yes,
Starts from 19.
the club with MC number so and so, leave their evidence so and so. What is MC number 1063?
Lord, 1063 is the filed by the husband
Seeking divorce.
seeking relief of the conjugal rights, my lords.
Restitution.
Restitution conjugal rights.
Then MC number,
And MC number 617 of 2023 is filed by the wife seeking divorce. Before filing, the trial, before the family court, first filed divorce petition under section 12, nullity of the marriage. Thereafter, they came to know that the corrections has been done, enter prayer and some other paras is also corrected by the 6 rule 17 applications also filed. Later on that, we have also filed objections with regard to that application. Therefore, the honorable court has passed the orders. In respect of that, we have filed one more writ petition number 3002 of 2025, my lord.
what happened to that?
Lord, that is also pending consideration, my lords. That copy is also served to the caveator, my lords.
So what is wrong with clubbing of the matter?
Lord, the sections are the different. So, the section 9 is the seeking for the conjugal rights. Section 12 and nullity of the marriage. Section 13 subclass 1I is the cruelty ground, my lords.
Parties are one and the same.
Lord,
Parties are one and the same.
parties
So
are one and the same.
Yes, the same
Lord,
evidence can be used.
Prayers are different.
In
Burden
RCR
of law is
petition-
different. And I will request, my lords, before the trial court, before the family court, till today, the wife was not placed assets and liabilities before the court, my
That's a
lords.
different aspect.
Please, my lords.
That's a different aspect. Why it shouldn't be clubbed, I'm not able to understand. It should be clubbed so that the court's time is also saved.
Blood, the prayers is different, but
Doesn't
even,
matter.
even before
Court knows
filing
what
of
is
the
the prayer
conjugal
and
rights.
We are seeking counterclaim for divorce as well in the RCR petition as well, my lord. Both
Even
the
that also
petitions are
prior
for
to-
divorce only.
No difficulty for this. Agreed with orders passed in 21.
Blood, I request my lords to kindly
That we
post,
will hear it independently.
blood, post along with kindly pass the,
Okay.
in the same petition, blood. The
Agreed
same
with orders
petition,
passed
same
in
prayer.
21 agreed with the orders passed by the 6th additional principal judge family court Bangalore dated 21/4/2025, whereby the court has clubbed MC number 1063 of 2023 along with MC number 617 of 2023 and the parties were directed to lead their evidence in MC number 617 of 2023. The husband is before this court. Husband or wife?
Husband.
Husband is before this court. Husband has filed MC number 1063 of 2023, and the wife has filed MC number 1060 of 2023, seeking restitution of conjugal rights, and the wife had filed MC number 617 of 2023, seeking divorce.
Divorce, my lord.
Seeking divorce.
Nullity of
MC
marriage.
1063 also, I am claiming divorce, my lord. Counter claim, I have paid court fee and seeking divorce.
1063.
Please.
In 1063, the wife has filed a counterclaim seeking divorce.
Please, my lord. And 617 is also for divorce.
So counterclaim. The land counsel appearing for the petition submits that initially she filed an application to declare the marriage as nullity. Thereafter, an application is filed under Order 6 Rule 17, and they sought for they sought for the divorce on the ground of cruelty.
Cruelty, please.
On the ground of cruelty.
But with
When
permission
that
of the court, one
application is-
submission.
huh?
That's permission of the court, one submission. The one more writ petition is at 3002 of 2025. Kindly by tomorrow, maybe kindly.
The Order 6
Aman.
Rule, questioning the order passed by the court allowing an application under Order 6 Rule 17. The petitioner has filed WP number
WP number 3002, my lord, of 2025.
002 of 2020.
5, my lord.
Has filed so and so of 2025. Land counsel submits that the both matters can be heard together. Land counsel appearing with the respondent submits that there is no prejudice to the petitioner when these two, no, the land counsel for the petitioner submits that the relief that is sought by both the parties is different. The sections are different. So there cannot, the cases cannot be clubbed. Having heard the counsels on either side, but it's a material on record. The two parties, there is no dispute that the parties are one and the same. One is seeking restitution, other is seeking divorce. And in fact, in the restitution case, there is a counterclaim for divorce, and there is an independent case for divorce. In these circumstances, this court is not able to understand what is the difficulty to the petitioner if these petitions are clubbed and the evidence is let in the divorce case, which is in the divorce case. This would be convenient for the parties as well as convenient to the court, and court had rightly considered and passed an order, and this court do not find any reasons to interfere.
Even assets and liabilities also not filed, my lord.
That is not that we can't consider that number. That number list the matter on Monday. Give the number, it will come on
Please,
Monday.
please.
Grateful, my lord.
Dispose it. Just next.
Serial number 14.
The petition is for enhancement. There is no interim order, kindly. Notice may be issued, and one more submission, my lord. The other side have filed the petition, has taken.
Post along with so and so.
Please.
Notice to the respondent, post along with that.
Serial number 15.
I per the petitioner in this case, my lord. The father filed the GNWC petition before the trial court Shimoga. He has filed the interim application for visiting rights. That application is rejected by the trial court. The order is page number 43, my lord.
43.
Yes, my lord. The only contention, my contention is that the order I have been permitted to read.
Why don't you take hand summons to the council?
Please.
Immediately after the hand summon memo is filed, it will list.
Please.
Yes.
Oblige.
Notice hand summons to the council for the respondent. Once memo is filed, list the matter.
Oblige.
Submission, serial number 16.
In this matter, my lord, offer for petitioner, my lord. In this matter, my lord, the petitioner is the son of, my lord, the respondent. When they file the petition, my lord, you are.
For pass over, seen his hand up in other court. How many
And,
times the
230.
matter has been adjourned at your request? Maybe passed over, At the request of land counsel, the respondent, call the matter. At the request of land counsel for the respondent, list the matter.
It may be passed on, my lord. He's held up in that.
List the matter on Thursday. at the request of non-counsel, the respondent.
Serial
Yes.
number 17.
My lords, in the
Petition on the petitioner.
in the first matter,
Okay,
I
right
appear
now,
for the
petitioner.
respondent.
If your petitioner come this side.
Please.
Yes.
My lords, there is, in the first matter, I appear for the respondent, my lords, and in the second matter for the petitioner. However, my lords, there are certain settlements that we are trying to work out, my lords. If your lordship could refer this to Lok Adalat on 12th, my lords.
Please.
Both the parties submits that there is a likelihood of settlement. Accordingly, the matter is referred to the local court. Industry is right to pay.
Grateful.
Yes, next 18.
Serial number 18. Serial number 18.
Query for the respondent in this matter, Your Honor. They have not complied with the order of this court, Your Honor. And
There
no
is a counsel
maintenance
for the
has-
petitioner. No representation on behalf of the petitioner. Counsel of the respondent is present. This is a matter for a dismissal on Tuesday. Yes, next.
Serial number 19. T. Prakash.
Appear for petitioner. Only 1 week time may be granted.
When was the interim order granted by this court?
Lordship, this honorable court passed the interim orders on 21/3/2025. Within 2 months, they have
To the
to
condition that the petitioner
deposit
pays a
the,
sum of rupees 2,000 per month to each of respondent number 1 and 2.
I clarify.
Continues to
5,96,000 they have to deposit.
5,000 per month to respondent, not the 9,000 per month. Shall also pay entire areas at the rate of 9,000. What has happened to this?
Deposited or not, I clarify. My lord. 1 week time may be granted.
He is saying not deposited.
They have not deposited.
This court has passed an interim order on 21/3/2025 directing the petitioner to pay 9,000 per month towards the maintenance until further orders, and also to pay the entire arrears of maintenance at the rate of 9,000 per month within a period of 2 months from the date of order, that is 21/3/2025. Then counsel for the respondent submits that the order of, they have not paid the maintenance and the order of this court is not complied with. Then counsel for the petitioner seeks time to get instructions. List this matter on 14th of August. By the time, if the interim order, if the amount is not paid and the order of this court is not complied with, the stay granted by this court stands vacated.
Please.
Serial number 20. Serial number 20. Girish B. Baldare for petitioner.
For petitioner, my lord, the marriage was solemnized between
What
the
is the
petitioner.
impugned order?
My lord, the impugned order is the respondent shall pay 10,000 for the
Shall pay
petitioner
10,000 per month.
two and
in
5,000 for the
lifetime.
respondent.
5,000. To petitioner number 1. Petitioner number 2, 10,000. Petitioner number 1, 5,000. Altogether 15,000. Yes, what are the grounds? What is your income?
Income is not disclosed, my lord, and no documents are produced.
You are appearing for whom?
Petitioner, my lord.
Petition is wife or husband.
Husband, my lord.
Your income you only have to disclose. Who else will say? What is your income?
My lord, as 50,000.
50.
50.
When you have 50, what is the difficulty to pay 15?
My lord, kindly make it.
What is to be done kindly?
Kindly we make it 10,000 or.
If it is 10,000, it's fine. The land counsel for the petitioner submits that the court has granted 15,000 as maintenance and is not in a position to pay. And all the aspects were not considered by the court. Considering the submission of the petition, there should be stay of all further proceedings on the condition that he shall pay 10,000 by 5th of every succeeding month and to 5,000 to the first petitioner and 5,000 to the second petitioner, and continue to pay and arrears at 10,000 within 8 weeks.
Serial number 21. Preliminary in B group. Notice.
Much obliged.
Notice is not ordered till now. No? A notice, yes. 21.
Serial number 21.
I appear for petitioner.
Where is the respondent?
Virupakshaya.
Give the file. There is no representation on behalf of both the parties. You have an interim order in this?
Yes, Your Lordship, in the second matter, there is an interim order. In fact, in the first matter, that is the same continuation of we have challenged the execution warrant. That the first matter, that there was no, initially there was interim order, subsequently it was not. By oversight, it is there I just want to bring it to your notice, Your Lordship. And in fact, this.
I'm not able to understand. What is it? What has happened?
What
order it is?
Challenged.
No.
Yes.
Interim order is extended every time.
Correct. That is in the first matter. Initially, there was interim order. Later on, it was not there, Your Lordship. It is big. So I just wanted to bring later. It shouldn't be that.
It is not even extended.
In the first matter. Second matter, there is an interim order. From time to time, it is extended.
So in this, on dated 3/6/2025, it is not extended.
Yes. The second matter, there is an interim order that's extended.
Interim order is extended, no representation for the respondent. Lists matters on 28th of July.
Please.
Yes.
Bill number 22.
Appear for
Number
petition.
22.
Appear for petitioner, my lord. My lord,
Would
writ
you
petition
talk-
has become infectious, my lord. Kindly, it may be disposed of.
How it has become
My
infected?
lord, the matter has been referred to mediation from principal, family court
It
principal.
is settled.
Please, ma'am.
It is submitted that the main MC itself is settled between the MC. This is arising out of criminal miscellaneous or MC?
Criminal misdemeanors.
The C miscellaneous is settled between the parties and this petition has become infectious, dismissed as infectious. Yes, next.
Bill number 23. GM Srinivas Reddy.
In spite of interim order, my lord, they have reduced from 5,000 to 2,500, my lord. It's very difficult for the respondent. She has got 2 children, my lord. And education.
Where is such report?
AMC.
You appear for the respondent.
Please, my lord.
So kindly, we offer the site, my lord, regarding the settlement and other things, my lord. Regarding this, we offer the site for the.
That was not agreeable by the respondent, my lord. He has got one site, one house, and also landed properties in Chittur, my lord.
Not in Bangalore itself.
No, in Chittur district also, my lord. They are married from.
Both of them from the Andhra Pradesh, my lord, Chittur. They are settled here in Elanka. We offer the site, my lord. We executed the gift deed in favor of the children and other things, my lord.
Second order arises from?
Criminal miscellaneous, my lord.
What was the amount granted?
My lord, the respondent is by directed to pay rupees 2,000 each per month towards the maintenance of the children and 1,000 per month for the maintenance of petitioner. In all, rupees 5,000 from the date of application.
So how much is outstanding now?
Day to day, we are paying the maintenance.
Any outstanding amount is there?
My arrears has to be paid, my lord.
How much?
My lord, last.
Respondent should file a calculation memo before this court. Yes, next.
Date may be fixed, my date may be in my lord.
List on 16th.
Cell number 24.
Wait,
Yes.
please, your lordship.
Evika.
That's the
for
proposals
petitioner.
were asked to
Anjana
be
test.
given in this
May
case.
please, my lords.
This is a matter where the
remember.
mother is in US and the custody of the child. So probably your lordship will recollect.
If my lords
The
will
parties
permit
were
me
asked
to
to
file
give
a
the,
reply to the proposal that's been shared by
whatever
the.
it is, my lords, now that the
Told.
stage has come where both are not
Please.
agreeable on agreeing on some proposals. So now we request this honorable court on 2 counts, my lords. One is, this is on the jurisdiction issue, this matter has come up before this honorable court. Make a very 5 to 10 minutes of submissions on jurisdiction point of view, so that that matter has come up before this honorable court on jurisdiction. That's one thing. So that after permitting.
No, the mother, when she went to the Supreme Court said with regard to the visitation, in the pending writ petition, the orders can be passed. With regard to the visitation and about the child's this thing. So that's why, because without going into the further complications.
I really understand. That is
Without
the,
going into further complications, like going to the, going around the courts like this. wanted a
we
settlement.
tried, Malars. The question here is, Malars, one is the temporary arrangement that needs
That's
to be done.
what, at this juncture, that can only be done.
and-
We're not going into the merits of the matter.
My lords, there is one more aspect here that I really appreciate that has to be done. In addition to that, the present writ petition is on the question of jurisdiction, because the family court held that the court has got jurisdiction, whereas now we have challenged it. Ultimately, this honorable court may also say it's a question of jurisdiction, that court has jurisdiction or will not have jurisdiction. Some order will be passed. Based on that, my lords, if this court comes to a conclusion that this family court has jurisdiction, then probably the matter will go back. Again, it will be in the family court only. And there, your lordship may kindly fix some date, limitation for the expeditious disposal of the case, considering the date of filing of the petition. That's one.
Which year is this MC filed and the JNWC filed?
JNWC is filed by the father.
Which year?
2020, my lords.
2020.
Now it is
Now
in the
the
stage
child-
of recording petitioner's evidence has been recorded. Examination in chief has been recorded. They are to
And
cross-examine the witness.
There was no.
It would 2020 JNWC will take some more time.
That's one thing. That's a little. That's
So what is happening is, in the order that is passed in the habeas corpus, and how it is understood by mother, how it is understood by father, that is what is creating the difficulties. She wanted, in fact, she was raising lot of concerns. The court has interacted with her.
We
And
know,
then because of that, the court said, no, the sending the boy to US and all at this stage, giving permission to leave the country will not arise.
One more.
So whenever she comes, how it has to be. First, we have to deal with that.
That's where two options were given here, Maros, from our side. Maybe the other side, father has also
So
given
let me
his
just
own
see
concerns.
what is that you are saying and what is that
Please.
they are saying.
Please, Maros. Basically, two proposals, my lords.
Is petitioner's
Petitioner's
parenting
proposal, my
proposal-
lords,
Petitioner,
essentially seeks, my lords, the custody be handed over to the mother.
That cannot be done.
That-
You know, what I'll do is, let me look at it. We'll
Yes.
pass an order.
May I
Let
just-
it be an order of the court.
may I just
Just can you read this
Read on the
petitioner's
proposal.
parenting proposals? It's by the mother.
please,
I'm sorry.
Maros.
Petitioner is the mother.
Petitioner is the mother.
Parenting proposal.
Please, Maros.
Please.
Para one in the we can straight away go to. Plus, until the JNWC
This
case
is our
is
reply. That's their
decided,
proposal.
child is
And this
permitted
is
to
our
stay with
proposal.
her in India is what we have submitted. And this will ensure that the child does not miss both
Why she'll
parents.
stay back in India?
That's where the next steps will come, Manas, what she proposes. The petitioner will stay at the Icon Apartments with her brother so that Vihan can continue to go to the same school where he is attending presently. Now, as it is, there is an order which permits her to have the custody of the child when she is in India.
This is 1 and 2 are not at all, there is a lot of confusion in this.
No.
No, when she says that, until the GNWC case is decided, the child is permitted to stay with her in India.
Correct.
This will ensure the child. So is she saying that she'll stay back in India till GNWC is decided?
That's where, my lords, we have mentioned that her education, her job opportunities and other things also we have explained in the next one.
No, court is not telling her to stay back. That's her statement here.
Please, my lords, I'm bringing to your lordship's kind attention whenever she is here, my lords, she will be with the child. In her absence, now because the child had expressed some concerns, my lords, she is trying her level best.
That is unfair on the part of the mother. You don't be here and you don't want the child to
be
have
with
the
the
company of the father also. That is very unfair on the part of the mother. That cannot be considered. How can she say that? First of all, when you're here, you want to
Where
be
is
with
the
the child,
mother's-
it's fine.
My lords, she has said that she is trying to, that part is not mentioned here. I'm very extremely sorry about that. May I just take it forward, my lords, with the.
What kind of proposal she is giving? During the period of petitioner stay, she will ensure that so and so. And when she is not there, he'll be with her family.
Which for a limited period, my lord. Supposing she has to work from home from here, she is trying to get that permission so that she can work remotely. And there are some circumstances where for 10 days or 15 days, if she has to go, then in that period, she has to make some arrangement. Even during that period, the child and father can bond. But principally, the child will be in one place is what we have suggested. That's all. That's all is suggested.
Then what is from your side?
Lords, whenever she comes to India, she can have the custody. No difficulty.
No, let's look at.
They're all staying to, father
Lords,
is
may
staying in
kindly
the
see the
same.
proposal. Lords, we have indicated that joint decision making and responsibility number 1. Respondent agrees to consult the petition mutually and decide on all significant matters related to the minor child. It may be education, health care, extracurricular and developmental activities. Anything is open, we are open to everything. 2. In the event of disagreement, both parties shall attempt resolution through direct telephonic communication in good faith. In emergency situations, the respondent shall take necessary action in the best interest of the child, inform the petitioner via email and text message the earliest possible. Petition shall remain accessible via phone. Then communication and information sharing. All communication between the respondent and the petitioner shall be respectful, professional and strictly related to the minor child. Primary mode of communication shall be email and text messages. If mutually agreed co-parenting application, namely our family wizard, may be used for all information sharing and documentation. There is one website, which app where we can share this. We can just log in so that every information is shared. No difficulty. Then next, each party shall respond to non-urgent messages within 48 hours. No derogatory or negative remarks shall be made by either party in the presence of the child or during the written communication or telephonic calls. Both the petitioner and the respondent should try not to influence the child against each other. That child's access to both parents, that as the custody of the minor child is with the respondent presently, respondent ensures that the child has reasonable and regular access to the petitioner via phone or video call, subject to child's school, health and activity schedule. If the child is unresponsive, the parent seeking communication may contact the other to coordinate access.
Broader principles.
Both parties
Co-parenting.
shall maintain equal opportunity for communication when the child is in other's custody. Petitioner shall intimate the respondent father of her intended visit at least 2 weeks in advance, clearly specifying her arrival and departure dates, as well as her proposed custody schedule during the stay. Such prior intimation shall enable the respondent to make all necessary logistical and academic arrangements in the best interest of the minor child. Then access to child's records and activities. Both parents shall have equal access to school records, including report cards, parent-teacher meetings, other communications, and the digital portals. Fortnightly academic updates shall be shared by the respondent to the petitioner. Joint attendance at school events can also be encouraged when both the parents are in the same city. Respondent shall also be present at any
Yes, I've
meetings.
seen that. Then what is this reply to the proposal?
Lords,
No.
this
To our
reply,
proposal they have
Lords,
given.
Lordships have
We
already
have not
seen the
given any-
proposal. Lords, we want to be fair. I don't want the child to feel that as a father I had deprived him of the love of the mother. The maternal love is deprived. I have not done anything till now in a manner that the child has got anything. 4 years, Lords, the child has been 6 years. The child has been with us. The child will not utter a single word against the mother. It will not. It may have something against me because I am parenting the child, but it will not say a single word against the mother because I have ensured it. I have not spewed venom in the mind of the child. I know my responsibilities. I know that the child is required to know what is meant by a mother, because once he gets married and there are children, he should also realize I have social responsibilities. I have taken care of it. Whatever they want, when with this, let them do it. In the GNWC, let them come and even now we had sent a proposal saying that, look, we are fair. What is it you want? You please suggest us. They want to come out with these kind of proposals saying that I will hold the entire custody. I don't want the father to have the custody. Let the custody of the children be with the grandparents or with the brother-in-law. All these things.
May I just intervene? Last 2 sentences.
Some fairness should be there, my lords, with which they come with the proposals.
I'm not telling that.
Notwithstanding, the orders are against them.
Yes.
I'm not telling that the child should be with the father or should be with the grandparents and brother. Brother and father instantly they stay in the same apartment block is what I'm given to understand. One thing that we proposed was she is trying for moving from US to here, and incidentally if that doesn't happen and in intermittent periods she may have to go here and there. So because of some concerns the child had expressed, Considering those things, we said that this will.
I spoke with the child. There are no big concerns at all. No big concerns at all. The mother was showing all that, whatever that, the parenting in India and the parenting in US makes sort of difference. And she's showing that over pampering thing. And what he says is when she is not doing something, he
I will
shouts.
just take your lordship to page 1 of our this one, my lords,
Proposal.
the writ petition. Now the case is set down for page 3, where the case is going on for on jurisdiction also. Let your lordship, I request your lordship to kindly pass the order on jurisdiction, whether this court has got jurisdiction, the family court has got jurisdiction on it. And about this parenting structure also your lordship may pass. And then 3625, I am given to understand there is one observation by this honorable court. Father has got visa issues, so the child cannot be, the custody cannot be given, is what you, in the course of the, probably in the course of what the father has said has come in that order. I request this honorable court to kindly clarify on that aspect, because assuming for a while, ultimately the family court.
What it was, why it was stated is, mother says boy wants to go to,
US.
she wants to take him to the US. Father cannot go because he has visa issues. So at this point of time, giving custody, whatever custody she's seeking to the mother is not, it is not right.
That should not, my only concern is that, my lords, assuming for a while, if it is a general custody case, my lords, ultimately the court may say the child.
Pending application. We are not determining the rights of the parties. It is pending application.
That observation, all that I want
that
with
I'll
regard to
clarify.
issues.
That
my
I'll
lords.
clarify.
That's one thing. And considering the holistic approach, whatever formula your lordship, my general submission to your lordship is going by what my learned friend has said here, is that child, whenever the mother is there, the child will be
with the mother.
With the mother. In case she is going for an intermittent period, she had suggested these things.
No, that will
that
not.
If your lordship, I'm
sorry.
just
Yes.
requesting once. In case the court is not with us on those aspects, that can be done. And in between, the child can also be, we thought that probably a structure can be framed where the child, father and mother can go for some counseling or something of that kind in a broader perspective. So that,
it's always in the interest.
And this last paragraph
Precisely, that is what that's what I want the mother to come up with.
I had given my lords,
The
I don't know
mother
why they
comes
have
out
given
of that
this.
cocoon, my lords, with which she is now.
No, she was raising concerns with regard to his medical and other conditions, that the father is not following the protocol and all. I said, that's what you come up. What all that you want to know? You want to know about the school activities, everything, like he's saying that there is that whatever that website
app
is
is there.
available app.
In fact, I had told them to put that paragraph. I don't know now this has come, and anyhow I leave it. One proposal, one second that.
No, both the senior counsel are now appearing. Throw some light on this to the parties and come up with a proposal instead of court passing an order. Understanding how you want, like what all her requirements she knows.
Lords, now, if she plans to shift here, is a change of circumstance which is not before your lordships. On the basis of conjuncture that whether she may or may not shift, an order
That
would
will
not
be
be passed.
considered at the day when she comes back.
No, that will be a change of circumstance which will be considered later by your lordships. As things stands, this is where it is, my lords. Whenever she comes to Bangalore for a limited period, whenever she is visiting, no difficulty, let them inform the dates with which she is coming. We will definitely
In
do
advance,
that.
it should be informed to her that when if she.
It's only for this purpose, so that there is a bus which picks up, so that we can request the school that they can send the other bus. They will arrange for the logistics.
We will.
So all these things can be done.
That's the day on which
Everything. Let them show pinpoint even a single finger at the proposal which we have given that this is not correct. We have been trying to be fair. Why this unfairness from their side?
May I just? It is not. We are not on an adversarial fight here. Only thing is, as soon as she books the air ticket, she will inform.
She will inform.
That's one thing. Second is this grandparent and extended family visitation only for 2 hours and all they have mentioned. That can, these proposals it will not be given by your lordship. When your lordship is proposing a structure, your lordship will definitely give a different plan. It may not be taken verbatim is all the time. Only for 2 hours, once in 15 days, 1 or 2 hours. When the child was with them, my lords, the grandparents, that's her mother's mother and her mother's brother were in active, contact with the child. So suddenly it goes to the father and father says, you don't go to grandmother. You can see here only once in 15 days.
Provided grandmother and the uncle
are
They do
staying
not
in the same.
pollute the child with
That
all
can
the
be.
information.
They are highly educated. Mother is MB, she is
the-
also highly educated.
The
Brother is
difficulty is with the
extremely.
educated people, because what my experience, my learned senior friend is also having the same experience. These child custody matters in those families which is not very highly
Problem
educated
is, however
or claim to be
educated they
highly
are,
educated, they are all right.
No.
I don't
Problem is whether educated or not, when the issue comes and it is a personal issue, all of them will be standing on the same pedestal. They'll forget everything. That's the whole problem.
Too much of information through education or knowledge
Can't
is
fix a
also not
formula
helpful.
for everybody's life. I mean, and every seconds event we can't fix a formula. I just leave it at that.
Well, that is one aspect. What else to be considered? Please tell them.
My lords, that
One is
30
with regard to the, mother's custody whenever she comes to India. And the
that
moment
has to
she-
continue, my lords. That has to
that
continue.
the moment she books her ticket, she will be informing him.
And-
Accordingly, he has to make arrangements for the
and that prior
giving
order,
custody of the boy
this
to
may
the
not
child.
be taken
But
as a
this
consent
is-
from my end, my
Yes,
lords.
yes.
That will be
This
an
is
order.
for the visits, if your lords were to, because now that they have expressed that she is trying for work from home,
That
etc.
I'm not going into that at all.
Yes, no, the reason why I am submitting is, let us assume a circumstance, my lords, that she gets this through and says that I'm going to come
The
for
other day-
6 months.
No, the other day your client was saying if she really comes back to India, then
Joint
you
parenting,
take
lords,
the
I will
custody.
concede.
He
Where-
said so. You take the custody.
Joint parenting, then we can easily have a joint parenting. I have no difficulty, my lords, if your lords were to see the manner in which I have said joint decision making.
I know.
Parents,
So with the first aspect is when she is coming to India, she'll.
but it's for the short visits, for which whenever she is
short
coming
visits
for the
and
short
how-
visits.
Why should we
Lords,
restrict
the
it?
reason is this: if she, let us assume, she comes for 6 months. Let's assume, because if she comes for 6 months, it cannot be that this is a proposal which will hold good for 6 months when she will have the custody, exclusive custody for 6 months. Not for the 3-4 days custody which she took straight from the school. I was unable to handle my child. Not, I don't want to
She was
express
staying for
my,
6 months at a time.
my
How it will permit her?
Lords may say a
schedule?
maximum period of 15 days at a given point of time.
Lords,
15 days, let her have it.
This is something.
For
which I-
example, if she's coming for the summer and all.
1
it is
month,
not
let her,
restricted.
your lords may fix it as 1 month. No difficulty.
my lords,
30 days, your lords
my
may
lords,
fix it
for
as
the-
30 days. No difficulty at a given point of time if you're visiting for once in 30 days, because the court had also directed once in 6 months if they want to travel, etc. Lords may fix 30 days in 1
That's
month
not-
if she is coming. Lords, I'm cooperating. I'm making a statement. If they come forward and say that let us take care of the child like this, I'm more than willing to do it. But the mother doesn't want to understand. The mother doesn't want to get out of the cocoon. Milords, for this 4-5 days, milords, my learned friend will also be aware, milords, for the 5-6 days of small duration of custody, I know the difficulty which I had to face with my child. This is not what should be done.
I'm not ever privy to that.
Because
May I just-
we have, milords, I don't want to say this because this is something which is between me and my son.
May
I have a responsibility. I have to convince him. I can't show her bad, and I'll have to convince him that I'm a good father. Not an easy task.
May I just submit, my lords? If he has completed, I will go ahead. My lord, the question here is, of course, your lordships will be aware, I can't be disassociating myself from career and also from the child is general proposition. But now, considering the welfare of my child, the child is missing. So it should not be looking like the child is shown a rosy picture outside so that the child is trying to go to America or I am trying to take the child to America. That cannot happen. For the simple reason, I am trying to come here. I am trying to see to it that most of the time I can spend with the child.
Then what happened to the father?
Pardon, Millers?
If 6 months you stay here, 6 months continuously the boy is with you. What about then?
Father also
from
can.
The last, no, from
Whatever
2019.
the orders, my lords. If
How your client wants it? No, from 2019 till 2025. Fine.
father was having, and I was coming intermittent here and there and going.
So
now
he has because he has been with the child and he has been taking
now
care
the
of
child's psychology is entirely different, Mars. Beyond 9 years, of course, even in the Western countries they speak, and your lordship had interacted with the child, and your lordship has said that there is nothing so dangerous or something that I'm
saying that I want to go to US, nothing else.
Nothing is there, is what your lordship has said. Now, my concern is only this, my lords. If the mother comes here and if they are suggesting co-parenting, then It cannot be only with the mother or only with the father, maybe
It will
their
both,
concern. That is their concern. How do we do it? How do we manage it? Supposing it is beyond, supposing.
Generally, like the 6 months.
Lords,
With
that
one
is,
parent
Lords,
and 6
may
months
kindly
with the
see
other
page
parent.
46 of the writ petition.
Page?
Page 46.
I'm requesting this honorable
Para
court to
14,
go
there is already,
beyond all
Lords,
these things.
there is already an observation by the division bench. Lords, your Lordships may consider. I don't say that page 46, which is internal page 17 of the division bench's order in the habeas corpus petition, para 14. For the aforementioned reasons, in our opinion, in the best interest of the child, he should be allowed to stay with the respondent in India till the decision of the issue pertaining to custody of the son in a proceedings under the Guardian Wards Act is adjudicated. Having said that, Lordships may kindly come to page 48, clause 4 and clause 5. The respondent shall provide tickets by air to the petitioner every 6 months to enable her to travel to India to meet the child at her convenience. Petitioner shall intimate her desired visit to India to meet the child to respond in advance.
No doubt an order was passed. No, what is the difficulty? No, mother is coming. No, if it
But
is.
see, in
let
that
me say
changed
legal-
circumstance,
No,
Lords,
2
now
months.
the mother should not bring about a circumstance which is not before the court. Now, what is now before the court is what is the circumstance which is prevailing, which was passed at the time of filing the writ petition itself. The habeas corpus circumstance has not changed now. Now, if she wants to say that, no, I'm planning for this, that is an eventuality. Your Lordships may reserve liberty to address it at a later stage. But as things stands, what has been directed by the
she is in
division
India.
bench?
No, the present situation is that is there prevailing now.
Let
No,
us
she is
go
in
to a-
India. No, she is in India. She will stay back for another 2-3 months.
Or I'll stay back for a
What
week.
is the situation that we have to look into now?
Milords, in that event, that's the reason. If that situation arises, Milords, certainly we will come and seek your Lordship's indulgence.
No, my lords.
That we will seek your Lordship's indulgence for that 2 months or 3 months. Let her have 1 month. I'll have 1 month. In between, we'll have custody. These things can be worked out. But on a speculation that she wants to come, or by stating that I am having a plans to come and unconditionally you give me a custody for a period whenever I'm in India, Milords, may be a little disastrous, because she has already said it, that I am planning to be here for 6 months or 7 months, 10 days I'll go and come back. So it should not happen that 10 days I'll get custody.
In all the eventualities we have to look into. And we say, what is the cap for that?
Total period, Milords, I was reasonable enough to say, Lordships may put a cap of 30 days. Milords, the division bench said 6 months once.
2 months.
Once in 6 months.
May I just
2 months in a year, Milords.
Let her go in 2 months.
Milords,
Whenever she
Lordships,
comes.
Milords, let us assume a circumstance. 2 months at a go, and then she goes back for 10 days and comes back again to India for another 2 months. It can't happen like that, Milords.
So that's why you have to say how it is.
6 months, Milords. That's the
She's coming from yours. You say that.
no problem, Milords. We have never, Milords, whenever she has come, it is not that she has come only twice to India. The direction of the court was she can come twice in a year, 6
No.
months.
There is
If
no
your Lordships were to see the direction,
he can
The
give
direction
tickets.
is for you to pay the.
so whenever, Milords, we have paid for it, whenever she has come to India, we have never, Milords, now, if your Lordships were to see this order, during the period of her stay, when she comes to India from USA, as aforesaid. So whenever this happens,
It is like
but
this, in the light of the. order.
no difficulty.
No,
Milords, I just wanted to say show the bona fides, Milords.
In the order of the Supreme Court, no, Supreme Court has said that wherever that is pending before the writ petition pending, no, we cannot, you can't say that what is said.
No,
in
no,
the-
Milords,
in
your
that,
Lordships may not.
habeas corpus
No,
order,
no,
we
no.
can't
Your,
alter
Milords,
it.
your Lordships may not feel that I'm requesting that your Lordships will have to maintain this order. Certainly not. I can never make that submission before Lordships. I'm only trying to say, despite this observation being there, whenever she's come 4 times or 5 times, this is adhered to by me. I have never breached it. This is only to say that I have acted bona fide, Milords, that whenever she comes, but now that she expresses her intention that this is what she wants to do, Lordships may safeguard my interest that at a given point of time, not more than 30 days. If in case there is any revisiting of this order required, your Lordships may reserve liberty to both parties, no
No,
difficulty.
we'll say something like this, 2 months, then.
6
whenever-
months to, Milords, if once in 6 months, if she is coming here, 2 months in a go, or 2 months, Milords, in totality, no problem, Milords, because we have been cooperating. Now it should not happen, Milords, that for these 2 months, she comes 15 days, she goes back, again comes back for 2 months. Then the whole period, Milords, will be with her. And that will be an order of the court.
May I just
So therefore, Milords, I don't want a circumstance, Milords, should not be brought about in a manner that I will be in a fix because I'm in your Lordship's hands. Lords, it's only a simple situation, Lords, that if she wants to do this, then for a longer visit, if she wants to undertake a longer visit for more than 130 days, then she has to approach the court and seek your Lordship's
That
indulgence.
is impossible,
But
my lord.
she
May I
has
just,
never come for a period beyond 30 days, my Lords. I've got the entire data. 12 days, 14 days, 18 days, that's all what she has come. If she wants to come for a longer period, let us assume, my Lords, if your Lordship feels 2 months is reasonable, to more than 2 months, in a span of 6 months, if she wants to come, she has to approach the court. Otherwise, your Lordships may put a cap of this. Otherwise, my Lords, what happens is, I am not coming against the parenting by the mother. I am making my stand very clear.
In that case, it becomes 4 months in a year.
Lords, that becomes 4 months in a year because she has plans. As things stand, she is staying there. But if she comes back, that is a different circumstance which is not before the court.
Please only restrict your arguments.
That's all, my Lords. 4 months in a year, my Lords, if your Lords, that's essentially what I'm submitting. 4 months in a year is more than substantial when she is abroad. And I'm saying unlimited access, everything, whatever she wants. If she comes and settles here, my Lords, and they come before the court, I can definitely assure, my Lords, I have pushed this person to this. I have
there is a
ensured, my Lord,
repetition
that this is
going on
the.
here. We have understood. Probably my learned friend's concern is that at a stretch beyond 2 months cannot be permitted is what they would say. My only concern here is this, my lords. Now, because of the concerns the child has expressed, now she may come, she may forego everything that she has earned, and she may come here for 3 days, 4 days leave also and may go, only to have the subjective satisfaction being given to the child that I am with you also. I am also with you, to show that. For example, whenever her purse permits, whenever her job profile permits her, she may come here and have access to the child. That's one part of it. Assuming for a while she gets 2 months or 3 months leverage where she can come and stay in India, then also she will have that. Your Lordship may kindly have this broader perspective and kindly formulate a structure for which will be binding on both of us.
Just to supplement what my learned friend said, my Lords, if she is coming for 2, 3 days, 4 days in between, my Lords, absolutely no difficulty. My Lords, we are not coming in the way.
Throughout the year, every month you can come.
Pardon, my Lords?
Throughout the year, they can come, my Lords. At a stretch, only your Lordship is putting a fix.
If you come for 2 days, 3 days, 4
Or
days.
1 week or whatever it is.
Even 1 week also. If you come like every 2 months, you come for a week, then that's not a problem.
Yes.
But problem is at a stretch, if you are there, what he says is also right. Then 2 months if she is there, and it happens every time you come, then what is not directly you couldn't achieve, now it is happening indirectly.
May I just, for example, I may come and stay at your Lordship will fix the cap. For example, 2 months, 2 months. For example, I'm coming from there, leaving everything, foregoing my salary.
You will say like this.
Then,
no, it is like this. No.
8 months versus 4 months, let us not get into that. Supposing 4 months I am entitled, for example, 2 months, 2 months, whatever it may be.
Yes.
4 months I get. 8 months the child is with father. We are not on that, my lords. I'm requesting your Lordship to kindly consider at a stretch, if it is beyond 2 months, it is not permissible or something of that kind. Probably the court can structure or whatever it is. That's what his apprehensions are.
Be an outer limit. There should be an outer limit. What is the maximum time in a year, here and there, whenever you want to come?
6 months, probably. 6 months for him. Anyhow, the child, I'm not entitled to take the child outside India.
Joint parenting plan, it is 6 months, Mr. Senior Counsel.
Lords, if she comes to India and stays in India,
I think in that matter you only assisted the.
Lords, that's what I said. Lords, if she is in India, Lords, in that matter, I wanted to submit this because I wanted to make a comment. Lords, the child was, same thing happened. The child was brought to India. The father was an IIT, IIM graduate. He was earning a big money there. It's astronomical figures, as I've seen that. The moment the child was brought, the father didn't care about his job. He came here because what he wanted was the child, not the job. And he fought for it. Then I had to intervene because the court requested me to see whether it could be done. He was not he was appearing as a party in person. I had to somehow prevail. But good sense prevailed ultimately on both the parties. Ultimately, parties will, whatever orders are passed by the courts, will remain on the papers if the parties don't want to intend to act upon it. It should be acted upon in good faith. That is how, my lords, a father behaved there. There is a reason when the father had done this. Mother has stayed away from the child for 6 years and wants to say that, no, I will do this. No. What is your bona fides with which you are acting if it's to be so? But I will show my bona fides. And not a single word the child will tell against the mother. Not a word the child will say against the mother.
No, we are deviating from this subject.
Yes.
That about the 6 months.
My lords, the 6 months is concerned. My lord, that is the reason why I said this is a circumstance which is not yet brought about. If they want to come and stay here for the entire time, then definitely, my lords, there is a certain guidelines which is laid down by the division bench for joint parenting. That's something which can be worked out. But that is not something which is there. Now they should not hold something in contemplation and then get orders of the court. Now they want to hold something in contemplation and seeking your lordship's indulgence.
Okay. From January, like for first, in that 6 months, 2 months period.
2 months. Lordships, it is very reasonable because if in case she has to come back to India and stay for
Not
6 months
continuously,
in
your
a
lordship may
year.
write, my lords. For example, I stay, for example, in a whole year, 6 months with me, 6 months with him. All the 6 months I may not be here. If I am here, broader perspective is 6 months is the larger bracket within which we can work. 6 months period, supposing all the 4 months, 2 months, after 2 months, there can be a break, for example, as your lordship said. And if I don't want that, supposing I can't come, then that 6 months period is available for me. Whenever I come 10 days, 3 days, 4 days also, let them, we will give a mathematical calculation of the number of days the child was with me. And equal parent, whatever he says, I will do, I will also do for him.
My lords, very simple.
Both. Let us be
I really
governed
fail to
by.
understand all these
Let
days.
us be governed by the same laws for
Lords,
both.
I'm really lost in my own thoughts. Mother did not want to come for all these days. Now she wants, I want 6 months.
Because the child.
Lords, no, I have never objected. Whenever the child has come, whenever the mother has come, my lords, she has, in one of the years, she has come 6 times in a year. We have never said anything. The moment she intimates that she is coming,
That's
we have
what
sent
we are
the
telling
child.
now also.
No, there is no way, my lords, that they will now call the shot saying that, no, I want to have 6 months. No, it cannot be done because we are having orders in our favor. Liberty is reserved, seeking visitation rights. The lords may kindly see, my lords, what is the order passed by the Supreme Court? Because their grievance before the Supreme Court is that there is some obstacle in the manner in which their visitation rights are being obstacled. That is the reason why the Supreme Court gave the liberty saying that we did not stick to those technicalities. I am not fighting this litigation as an adversarial litigation. When I am conceding to these facts, they should also be fair. When I'm in a position to demonstrate my fairness, I am conceding to the fact that whenever you plan that you want to shift and then stay back in India, we can rework on this. This is on the existing scenario.
That will be done, my lords.
That will be on an existing scenario. I'm only saying that your lordships may fix. Aren't I reasonable by saying that even if she comes for 2 months in a year, I have no problems.
My lords,
I'm not opposing, my lords, like any other custody matter. This is going smooth. Of course, I appreciate the presence of my learned senior friend. It's going smooth, not like, but there should be some reasonableness with which they should do it.
Relocating, my lords, in case she is relocating to India, then the
Then we have
situation
to
is
revisit.
different. That's a different situation. But now, working from there, taking work from home from here and going back and forth, all those things, this is the temporary thing. And now I would like to place on record this Karnataka case flow management rules, my lords, where it prescribes a time limit of 9 months for the disposal of the petition, JNWC petition. All contentions can be left open. Now, probably within 30 days, the case will be, if you are with your lordship's order being there, the matter can be disposed of within 1 month or 2 months also. Then everything will come to this one, and then we will go to the division bench on as far as MFA is concerned. If we are agreed, if both of us are not agreed, probably that will fix the formula for both of us. Everything can be put at naught, my lords. That's what I am requesting the Honorable Court. One is a request for a direction to the trial court to dispose of the case in case this Honorable Court comes to a conclusion that the family court has got jurisdiction. Number one. The second is, my lords, the order that your lordship has passed, that one, that with regard to husband has got, father has got visa issues, that may also have to be brought in before the family court, and how the family court will structure it. The second thing. Third one is, my lords, third prayer from our side is that whenever the mother.
You please argue, submit on the merits of the matter also, so that I'll pass.
Please, my lords, I'll just. Your lordship may kindly come to page 1 of the writ petition. The synopsis, list of dates and synopsis. I'll quickly take your lordship.
Yes.
My lords, date of marriage 2008. The column is there if your lordship can lay hand.
Yes.
Date of marriage 2008. Child was born on 2011. Now 14-year-old. And then, my lords, they attended school in New Jersey from 2016 to 2019. October 16, the child was, they have a green card, and now all are there. All were there. Now the father has also come here. July, August 2019, they bring the child to India. Now, my lords, we moved the foreign court, and there is an order passed by the foreign court, and incidentally one document we want to place on record before this honorable court. There is an order passed by the foreign court directing him to return the child to US and to the mother. Despite that, the child was brought here, and your lordship may kindly go to the next page, page 3. I'll take your lordship directly to 13/12/2019. The petitioner preferred writ petition habeas corpus, and January 20, my lords, after we preferred writ petition, he files JNWC. January 20, my lords. Kindly see, my lords, I would like to give one more information to your lordship, which is not available on record as of now in this writ petition, but with a memo we are giving it. He has also filed a OS, wherein he has contended that the decree passed by the foreign court is not binding on him. Now, my lords, 2/3/21, I file a IA 2/3/21, my lords. The petitioner files an IA challenging the jurisdiction of the honorable court. Kindly come to the last 5, 8/11/2022, my lords. Last 7th column from bottom in page 3. Could your lordship lay hand, my lords?
1 minute. What is that?
8/11/22, your lordship will get a date. From there, my lords, that is the order passed on IA3 dismissing the, that's what is challenged before your lordship.
Please come to that order.
Next, all are case posted for evidence of the respondent. It has not gone till this day.
Yes.
Now, kindly come to this Karnataka case flow management rules, wherein I have given to your lordship. In the page number 3, ink page number 3, my lords. Ink page number 3, track 4, and there is some mentioning of track 4. Below that, my lords, the presiding officer shall endeavor to dispose of the cases in track 1 in 9 months, is what is mentioned here. Now, kindly see, my lords, track 1 on the left side, your lordship will get child custody, maintenance, etc. So that's one part of it. Now 9 months need not start from here. Your lordship may kindly fix an earlier period.
There are so many matters. If that 9 months have to be counted,
I know.
2016 matters are also pending there.
My lords,
the Bangalore court.
My lords, our humble submission is, now what happens is the child is 14-year-old. This is a formative year, is what we say. This adolescent age, my lords, normal children also we would have hated, we would have argued, we would have shown our rebellion attitude with our parents. That generally during this adolescent period we act differently. This is a period, my lords, where the structure should be such that
the boy is a citizen of yours.
No. Boy is a green card holder.
Oh.
Green card.
Born in India.
He is born in India. Now, my lords, this is one part of it. Now, coming directly to the
impugned order.
Impugned order, lords.
Number?
Really the page petition.
Page 152 to 156 minutes.
150. Document number 10, my lords, annexure G is what is mentioned. 154 it starts from reasons. May I read, my lord? Sorry, if your lordship has read, I do not want.
Yes.
Last paragraph in 155.
I've seen it.
2016 to 19, the child was there. 19, the child was brought here. Whether we can consider when the one of the parents has brought the child, and there is also a case pending before and there was a case filed wherein there was an order against the father to return the child. That order is also made part of the records along with the memo.
2014, they have shifted to yours.
Please, Mellors.
When you were 3 years old.
Page 10 of our compilation that we placed on record before this honorable court.
16 to 19, he was in New Jersey.
Plus 3/12/2019 is the order of the foreign court, which is
I've seen that.
Which we have placed on record. And his document is 12, page number 12, where the father has filed a claim. Your lordship may kindly
What
come
did
to.
he say with regard to the jurisdiction in the place?
That's where, my lords, your lordship may kindly see page 20. Page 20 of the compilation. Prayer. To declare that Superior Court New Jersey to try the personal law disputes between the plaintiff and defendant and guardianship and custody in respect of the child, as the plaintiff and
Where are you
defendant are
reading?
governed by the personal laws.
Where are you reading?
Page 20, my lords, in the compilation. Last. The prayer portion of the plaint alone I wanted to read. Instead.
Page 20 is a supportive affidavit.
The compilation that I now gave, that along with a memo, where your lordship laid hands to that Karnataka case flow management rules. In that compilation, it is there.
Yes.
Well,
page number 20 in this.
Last page. Prayer. I am only reading the prayer part. To declare that Superior Court of United States has no jurisdiction to try personal law. Personal law disputes between the plaintiff and the defendant and guardianship and custody rights in respect of the child. Next, my lords. To consequently declare that the proceedings
This is a different suit.
This is a different suit.
What is the suit? OS number?
6 of 2020.
6 of 2020.
Now, he has sought for a declaration which is yet to be given by the court. That's one part of it. Now the court has already, the foreign court has exercised some jurisdiction and there is an order passed by the foreign court, which is at page 10 of the compilation. Second paragraph. Plaintiffs it is on the 3rd day of December 2019. That date may kindly be noted, my lords. In page 10, your lordship will get it after the first para. Plaintiff's application for defendant to turn over Vihan Sudhir's passport and green card is granted. Defendant is directed to return the child. An extraordinary equitable remedy utilized primarily to forbid and prevent irreparable injury. Now, my lords.
What is this order now it is passed? What is this order? Just now you read. December 3rd, 2019.
This is an order passed by the foreign court directing him to return the child. He has not returned the child.
Defendant is directed to return the child to the state of New Jersey. Injunction relief is an extraordinary.
So it has not been followed by the respondent herein, that is the
Ad
father.
interim order is granted.
Yes.
Then she was asked to serve the notice.
Please. This is the status there.
Thereafter, what happened?
After that, nothing happened because he has not brought the child back to the court. 2019, this order is dated 3/12/2019. 3/12/2019. Post that he has filed the case here in 2020. After I moved habeas corpus petition here, that your lordship will get in the first page of writ petition. In the chronological events that we have explained, your lordship, on the
I've seen that.
third, now 13/12 I file a habeas corpus petition. This is one set of facts. Now,
The whole basis for the court to dismiss your application is already the courts, the High Court and the habeas corpus and other petitions have already interfered. So there is jurisdiction according to the court. That's a finding of the court.
That I wouldn't mind court passing, because this should not set as a precedent. My respectful submission to your lordship is, now the matter is before your lordship. In a habeas corpus petition, the court will not get it, whether it's an illegal custody or not, probably in that parameter, the court will work. That's one aspect. Ultimately, this court may also feel there is jurisdiction or not, that's a different issue. But that should have been independently seen. Immediately, I would have moved this court, that court, in an anxiety to get back my child. I would have moved different courts.
Yes.
That doesn't mean that I am subjecting myself to the jurisdiction of this court, or the child is covered under the jurisdiction of this court. That's all I'm submitting. I do not want to pressurize your lordship with anything. One judgment I will rely upon. Ruchi Machad. Court.
Yes.
Notes ಮಾಡಿದ್ದಾರೆ. One copy. My lords, this is a case where 11-year child, US citizen, Ruchi Mach's case, my lords.
You can come to page number 16, I think. Page number 16 you can come to.
15.
16.
Solitary test for determining jurisdiction of the court under section 9 is the ordinary residence of the minor. The expression used is where the minor ordinarily resides. So all these things, my lords, ordinary, everything is written, and paramount interest is taken into consideration. So I just leave it to your lordship. Now, my only request to your lordship is, the child was with, I would request your lordship to kindly look at it from this angle. The child, from its date of birth till 2019, it was ordinarily residing with both the parents. It was residing with both the parents continuously. And then from 14 to 19 also, it stayed in US with both the parents. Now the father has all of a sudden brought the child here.
So all of them have come.
On the ground that it is for a puja.
Correct.
For a limited purpose. It is for a limited purpose they had come. They never said that we are going to hold the child here itself. That was not the, otherwise I would not even have come here. They said, I am coming here only for the sake of the puja. That's where this court has said we have to look at the pleadings. Pleadings means from both sides. That's where we said the father never expressed the intention that once we go back to India, the child will continue to be in India. That was not the case. That's where, my lords, my respectful submission to your lordship is, today 6 years have passed. So since 6 years the child is here, that cannot be a ground, is what I am requesting your lordship to kindly consider. As on that day,
what the Supreme Court has done in this case.
Well, the Supreme Court ultimately has said that the child should return.
Let's read that.
I mean, the child should be,
Send
Your
back to
lordship
them.
will see the last page, page 58 of the,
Yes.
this was the reverse case, my lords. 57 from 57. Besides, the father shall be free to
Here,
visit.
the father has taken the child from India to US.
Where, my lords?
Yes.
Yes, my lords. Here, my lords, the father and mother were of Indian origin. The child was 11-year-old. In Ruchi's case, I am requesting. And the child was a US citizen. That is one thing. And father had a decree from the US court that the child should, and he had also had a decree of divorce from the foreign court in that case, in Ruchi's case. And then when the mother removed the child, then a red corner notice was issued. Then, my lords, mother filed a petition here. She came back here to India. She filed a petition under Guardians and Wards Act. She also filed an application, interim application under Section 12. So there was an interim order in her favor. That was challenged before the court here. The court said on the ground of jurisdiction, the court had dismissed. Then it is only the American court which has jurisdiction, because all the three are citizens of US and the committee of courts based on that principle that have. But the court ultimately, I have to bow down, my lords, the court has said something else where the more or less we stand in a different position, opposite positions here. 58, page 58. What happened in this case? For that particular purpose, I am requesting your lordship to kindly see.
No, where is the finding with regard to that
Yes,
ordinary?
this operative portion, if your lordship reads four lines, my lords, ultimately your lordship. The respondent does not remove the child from the jurisdiction of this court pending final disposal of the application. Could your lordship lay hands, my lords? 58. Page 58 of the Ruchi's judgment. Bottom is the page numbers are indicated at the bottom portion. 58.
Yes.
Kindly see, my lords, 7th line from bottom, the above. Some directions were given. These above directions are subject to the condition that the respondent does not remove the child from the jurisdiction of this court pending final disposal of the application for grant of custody by the Guardian and Wards Court, Delhi.
I think this 58 page start with for the vacations in summer.
They structured a formula, my lords, as your lordship is now proposing to do in this case. They structured a formula. I am being very fair to the honorable court. In this case also, court held that the child is already brought by the mother in Ruchi's case, as the child is brought here by the father and kept with the father. The court said in Ruchi's case that you can't shift her to US immediately. Let the child be with the mother only, because whether she has brought
that issue of ordinary place of residence, how it was decided, that I want to know.
That particular portion.
Yes.
The main reliance was on Dhanvanti Joshi's case, my lords. I have marked some portions instead of taking your lordship to all these things, my lords. First, I will take your lordship to page 5. Which is? Same judgment. Page 5, my lords, of the judgment.
I think it is dealt with at page 48.
Dhanvanti's judgment is there.
No, this court's finding, the Supreme Court's finding.
That's also there. Correct, lords. I have marked, my lords. We have, while dealing with question number 1 above, held that the court at Delhi was in the facts and circumstances of the case competent to entertain the application filed by the appellant. What needs to be examined is whether the High Court was right in relying upon the principles of Committee of Courts and dismissing the application. Our answer is in the negative. The reasons are not far to seek. The first and foremost of them being that Committee of Courts principle ensures that foreign judgments and orders are unconditionally conclusive of the matter in controversy. This is all the more so where the courts in this country deal with matters concerning the interest and welfare of the minors, including their custody. Interest and welfare of the minor being paramount, a competent court in this country is entitled and indeed duty bound to examine the matter independently, taking the foreign judgment, if any, only as an input for its final adjudication. Decisions of this court in Dhanvantri Joshi and Sarita Sharma's cases clearly support that proposition. Secondly, 49. The respondent's case, that's all on the facts of the case, matters. They have gone on this principle, and ultimately, as I read to your lordship, page 58, last paragraph, your lordship.
Yes.
Last
So
7
applying
lines.
that judgment to the facts of the case, what would be your submission?
I would leave it to the court. My lords,
So
let us.
there are two issues. There are two issues. Which is one is on the question of law, and the other is on question of facts.
Pardon, minutes, I couldn't.
One is on a question of law, and the other is on question of facts. Now, on a question of law, when section 9 says the court where it is ordinary place of residence, that court will have the jurisdiction. So that is not answered in this judgment.
No, it is answered. If your
Para
lordship so to say,
24.
it has gone very succinctly on all those aspects. Despite that, considering the paramount interest, court has
Where is
molded.
that particular
See, ordinary residence is, that's where I was drawing your lordship's kind attention from page 15. 15, bottom, the page numbers are indicated. Section 9 of the Guardians and Wards Act 1890 makes a specific provision as regards the jurisdiction of the court to entertain a claim for grant of custody of a minor. While subsection 1 of section 9 identifies the court competent to pass an order for the custody of the persons of the minor, subsection 2 and 3 thereof deal with courts that can be approached for guardianship of the property owned by the. Section 9(1) alone is therefore relevant for our purpose. Court having jurisdiction to entertain application. There, my lords, next paragraph. It is evident from a bare reading of the above that the solitary test for determining the jurisdiction of the court under section 9 of the Act is the ordinary residence of the minor. The expression used is where the minor ordinarily resides. Now, whether the minor is ordinarily residing at a given place is primarily a question of intention, which in turn is a question of fact. It may at best be a mixed question of law and fact, but unless the jurisdictional facts are admitted, it can never be a pure question of law, capable of being answered without an inquiry into the factual aspects of the controversy. The factual aspects relevant to the question of jurisdiction are not admitted in the instant case. There are serious disputes on those aspects to which we shall presently refer. We may, before doing so, examine the true purpose of the expression ordinarily resident appearing in section 9(1). This expression has been used in different contexts and statutes and has often come up for interpretation. Since liberal interpretation is the first and the foremost rule of interpretation, it would be useful to understand the literal meaning of the two words that comprise that expression. The word ordinary has been defined by the Black's Law Dictionary. Complete, my lords, it has gone into all these aspects. I am only on 2 points on para 16, my lords.
Yes.
If this application had been decided on the very first day, habeas corpus is different. What would have been, what orders the family court could have been passed has to be seen. As on that day, now after 10 years, these orders become, in a way, I wouldn't say redundant. In a way, it would become ineffective for the welfare of the child from the point of view of the child. Now, as on that day, what should be considered as the ordinary resident? Whether the child was ordinarily residing as on that day in India or in US, that has to be first and foremost considered. I'm really lost at sight when I looked at this, that despite there being a direction in our Karnataka case flow management rules also, when such cases are there, primarily they have to decide on these aspects. I understand that the courts are burdened, all those things are there. But there should be finality. I should know where I stand. So my primary principle is that, and one thing, though it's a mixed question of law, the factual aspects relevant to the question of jurisdiction, when they are not admitted, what has to be seen? One of the admitted fact, I say that it's only for puja they brought in here, and then suddenly they said that they are not going to return the child. I had to go back because of my job. Now they say a different version, disputed facts. But the fact, admitted fact is that both of us and the child remained in US till 2019. That's what needs to be considered. So as on 2019, what is the situation has to be considered is my response. That's all, madam.
Yes.
Can I just take 5 minutes of your lordship's minutes? Lords, they have filed this application for reconsideration of the judgment, etc. Lords, that is the Supreme Court's order is produced. Lords, if your lordships were to see that order of the Supreme Court at yeah, ill produced they had produced lordships would recollect the order dated 24/3/2025 passed with the Honorable Supreme Court.
The copy is given, I think, on the last of it.
Can I just pass on this, Milords? I understand. It just Muhammad copy. Could be first.
Yes.
Lords, I just wanted to put them on guard that what was relegated back to make an application is not what they are actually getting now. Lords, may kindly see the order. We dispose of this writ petition by reserving liberty to the petitioner to seek appropriate interim orders either in the writ petition or before the High Court or before the concerned family court as advised. Learned counsel for the petitioner also submitted that the petitioner intends to visit Bangalore in the month of April-May 2025. Therefore, seeks appropriate orders regarding visitation rights. Petitioner is permitted to do so. It is needless to observe that if an application is filed by the petitioner herein with regard to visitation rights or for virtual meeting with the minor child, Master Vihan, same shall be considered having regard. We are not sticking to that. The reason why I am submitting is.
So that is with regard to the visitation, but at the same time, this is before this court which
Yes.
has to be decided.
Now that's this was what was challenged was the
That is
proceedings
in the
of your lordships, and then the Supreme Court said you go back to the court and then you seek for now. So far as the merits is concerned, it is only twofold, my lords. There is something called as an issue estoppel. Lords, they came before this honorable court in a habeas corpus petition, and the habeas corpus court made specific observations regarding even the jurisdiction also and the remedies which will be available to them. If your lordships were to see the orders passed by the division bench, while passing the habeas corpus writ petition, lords, the order commences at page number 30. And can I take your lordship's attention, my lords, to because after Ruchi Maju, my lords, there is a development of law which is taken note of by the honorable by the division bench. And then if your lordships were to see, my lords, at page number 42, para 12.
Yes.
On the touchstone of the aforesaid legal principles which we have extracted for the facility of ready reference, we may advert to the facts of the case on hand. Solitary issue that arises for consideration of the writ petitions regarding the custody of the son during the pendency of the proceedings under the Guardian and Wards Act of 1890. The Committee of Courts is salutary in nature, yet it cannot override the consideration of the best interest of the child, welfare of the child. Principle of Committee of the Courts in the facts of the case has to yield to paramount consideration, overriding consideration, the interest and welfare of the child, which is to be answered in the facts of the case. The issue with regard to the best interest and welfare of the child is to be answered bearing in mind the totality of the facts and circumstances of the case. In the instant case, following circumstances has to be taken. First one, admittedly the son was born on 30/8/2011 at Bangalore. The son is not a US citizen. He is residing in India from the past 2 years and 5 months and developed roots here. Lords, then 2, 3 and 4 minutes. I will not trouble your lordships by reading into it. Then may I request your lordships may kindly come to paragraph number 14 at page 46.
Yes. Yes.
For the aforementioned reasons, in our opinion, the best interest of the child, he should be allowed to stay with the respondent in India till decision of the issue pertaining to the custody of the son is proceeding under the Guardian Wards Act of 1890 is adjudicated. Needless to state that the petition is liberal to prosecute a remedy in the courts in US. In view of the law laid down by the court in Yashishta Sahu Supra, it is trite law that extraordinary jurisdiction of this court can be invoked in the best interest of the child. It is also well settled in law The concept of guardianship of a ward is essentially different from custody of the ward. The court has to ensure that sufficient visitation rights to the parents is not given child's custody should be granted so that the child may not lose social, so on and so forth, my lords. And then the final order is passed, saying that at page 48. This is very important.
Yes.
It is clarified that the observations and findings in the judgment have been made for the purpose of deciding the controversy in this petition, which would have no bearing on the proceedings, which would have to be decided on the merits in the proceedings. So ultimately the merits is to be considered, my lords. There is something called as issue estoppel. If these are the findings which is suffered, now they cannot blow hot and blow cold. Lords, if they want to say that no, the court is
In a habeas corpus petition, court cannot decide the jurisdiction.
certainly
Number
not, my
one.
lords. But now
Not
there was a
decide.
direction given that you will have to go and pursue your remedies.
Remedies
Either
is
there or
already
here.
They have filed an application there.
Lords, that was considered. Now, if your lords were to see,
No,
that is considered.
Certain passing observations in an order
No,
cannot be
page
taken into
para 5, my
consideration.
lords, of the orders.
Will not go to the root of the matter.
Number 1. Lords, 2, my lords, if your lords were to see, Ruchi Maju's case para 24 has been read to your lordships. Ruchi Maju's case very specifically said, at the best, it is a mixed question of law and fact. You can never determine it as a question of law, as though it is a question of law. Lords, this was filed at a stage when it was a pre-inquiry. The application which is now rejected by the trial court and which is now impugned before lordships is at a pre-inquiry stage. So Ruchi Maju's case is being relied upon to say that this matter has to be considered. Ultimately, my lords, the contention can be kept open, no difficulty.
You have to look at a broader aspect. Now, both the parents along with the child residing in US. Now, they come to India. Suddenly, one of the parents says, "No, I will. The boy will be with me, and he will not go back to go back to the US." Now, admittedly, on the facts, on a plain reading, the ordinary place of residence is the US. Now, why the mother has come to this court and filed a habeas corpus petition? She has no other alternative.
Lords, now
What will she
this
do?
it did not stop here. The matter even has gone to the Supreme Court.
Correct.
Supreme Court
It's
has confirmed the
continuation of
orders.
that.
Lords, I'm only submitting, my lords, that whatever submissions would have been made at that juncture.
Particularly in the facts of the case.
Yes.
But there should be a clarity on this.
Lords, what
And the
happened?
Parents cannot play with the lives of the
My lords,
children like
this is essentially, my lords.
And first of all, what has happened now, the father has completely, he has lost the company of the mother for so many years.
Lords, now the contrary of it, my lords, I can just say that also. If your lords were to see the facts as recorded in the habeas corpus petition, lords, the mother is a career-oriented person.
Of course, why not?
She did not
What's wrong
want
in
to.
it?
Lords, she did not want to come.
What's wrong in it?
No, definitely nothing wrong, my lords. There's career when they take recourse to the career orientation.
No,
There
it
may
is-
be some compromise
it is-
with the
it
family
is-
ideas.
No, why should she compromise with the because husband wants to be in India, let him be in India. Like the son stays in US, he has a maybe better prospects.
No, that will be very disastrous statement to say that it's a child in US will have a better prospect than a child in
Not
India.
a statement.
No, I don't.
He may be, but no, the father has literally made the mother helpless by getting the child, by keeping the child with him.
My lords,
No, it should be decided.
this is, no, I would say this, my lords. The custody of the father is relatable to an order of the court.
No, one
The
more
court
thing.
would not
No,
say
no,
it at this
one more
juncture.
thing. No,
That
one
is
more
something which
thing.
is gone into by the division bench of this honorable court, confirmed by the Supreme Court.
No, anyhow, when the jurisdiction aspect,
Jurisdiction aspect is concerned, my lords. It is the Ruchi Maju's case, which is reiterated in many other cases, went to the extent of saying, at best, it can be a mixed question of law and fact, which is to be decided after a full-fledged trial. So at the most, what your lordships would do, but that's the reason probably why my learned senior friend said that it can be directed. So whereas directions to be given is concerned, my lords, that I'm in your lordships' hands. That I will, of course, I will never oppose. But your lordships may also have to keep in mind, my lords, that the pressure with which the family courts are functioning, because it should not happen that the court feels that we have brought some directions against the court, which because we have come across instances where the courts have expressed in our presence that you get directions, there will be other older matters, we are unable to deal with the older matters. So when the older matters is taken up, the courts expresses that because of a high court direction matter, I can't take up your matter. So that, of course, my lords, is in your lordship's prerogative. That is an issue, my lords, where I will not delve into.
Heard, reserved.
Lordship, so grateful, my lords.
Grateful for the patient.
Chair number 25,
Yes, 25.
25,
For the petitioners,
Sonia Rajesh,
Yes, what is the petition?
Bhumika, 14%.
Lords, the operative portion of the order is in page number 31 of the petition.
We'll continue after now. We'll continue after.
Also there. Afternoon. That one.
Continuation. Continuation. Yes.
Cell number 25.
For the petitioners, Your Lordship.
Sonia Rakesh, for petitioner.
Yes.
Bhumika, party in person.
That's the operative portion of the orders.
Page number.
Page number 31.
So come to the order, the reasoning part. Read from paragraph number 10.
The reasons being point number 1, the matrimonial relationship between the petitioner and respondent is not in dispute. It is not in dispute that they have a male child, Master Dhruv Chowdhury, aged about 10 years in their wedlock, and admittedly, the child is under the care and custody of the mother or respondent herein. It is an admitted fact that they are residing separately from April 2014, and the child is school going. Both the petitioner and respondent filed their affidavit of assets and liabilities. The affidavit of assets and liabilities of respondent shows her education qualification as BE, IT and PGDBM in HR. Petitioner is diploma in design in NIFT. Admittedly, petitioner is employed. In his affidavit of assets and liabilities, the petitioner declared his earnings as 3 lakhs per month after tax deduction. The petitioner produced copy of his IT returns for the assessment of 24 and 25, in which he declared his total income as 58 lakhs 42,220 per annum, which becomes 4 lakh 86,851 per month. The petitioner produced his payslip for the month of April 24 to July 2024, which reflects his annual income. The petitioner, in his affidavit of assets and liabilities, failed to refer his general monthly expenses in column A, serial number 7. The earnings of the petitioner is not in dispute. Subsequently, in view of the directions issued by this Honorable High Court of Karnataka, WP 26985 of 23, dated 3rd July 2024, the petitioner produced a copy of his HDFC bank statement and respondent filed her fresh affidavit of assets and liabilities on 24th September 2024. The petitioner produced a copy of the school fee structure of the child, Mr. Dhruv Chowdhury, with her affidavit of assets and liabilities. The respondent sought for maintenance of 2 lakhs per month, claiming that she is in need of 30,000 towards household expenses. She has to pay rent, salary to the maid servant, and she has incurred expenses towards conveyance and medical expenses. The respondent produced her bank statement maintained in HDFC Bank, which reflects the salary credited to her bank account by her employer, High Peak Software Private Limited. The bank statement shows that 2,69,000 was credited to her bank account on 2nd December 2021 towards her salary for the month of November 2021. On November 2nd, 2021, salary of 2,830 rupees was credited by her employer as her salary for the month of October 2021. Similarly, on 1st October, 2nd September, and 5th of August, she has received the same amount of salaries, which was credited to her bank account as a salary. The bank statement produced by the respondent shows that she was employed and she was getting handsome salary until 2nd December 2021. It is the specific case of the petitioner that the respondent quit her job to take revenge and pressurize him to heed to her demand after filing of this petition for the dissolution of the marriage. The petitioner filed this petition on 27th November 2021 under section 13(1) IA and IB of a Hindu Marriage Act, and respondent appeared before the court with her counsel in January 2022. Admittedly, as on the respondent is unemployed and she has no independent source of income. But the fact that she is well qualified and she is capable of fetching a suitable job and having ability to maintain herself is an undisputed fact. The records placed before this court shows that even before the service of notice to the respondent in this case, she quit her job. The respondent failed to assign satisfactory explanation for quitting
Yes, I see.
her job. My lord?
I've seen.
Yes. So currently, the operational part of the order states that the maintenance is given for both the respondent and the child. It is well established that the respondent herein is very much well qualified for herself. And if I may take your lordship through the assets and liabilities filed by the,
No, that's extracted in the order till 2021 she's working.
yes, until 2021. But in the assets and liabilities, the expenses that are shown, for example, around 20,000 is given for the daycare expenses. The child is 13 years old right now. And for private tuitions, 8,000 rupees is being given. So there is no logical explanation why she is not finding a job or in a job currently. So the petition at hand, it is for it is prayed that to set aside the order that has been passed by the third additional family court and limit the maintenance to the child. He is already paying for the child. He is indeed paying, which is the order right now is
Paying towards
30,000.
How much is paying towards the educational expenses?
The education expenses has not been furnished to us. It was directed to the respondent to furnish the fee receipts and all the things, but it has not been given to us. But currently, the modified order is that 30,000 is to be given to the respondent, which is being given. It is being complied with. He is ready to take care of the child, but not the respondent, my lord, since she's very well establishedly, she's capable of earning for herself.
Lordship. So may I just go back into a retrospect a little bit about WP 26985. You have ordered for 50K as for me and the child both, and you've ordered the trial court to address the rest of the case. So that order was not complied by the petitioner, and he continued to pay after 2 months after the order. He started paying 30,000. Once that started in the lower court, again, they concealed the fact he has, in the year 2023, he showed his salary as 67 lakh plus, and in the year 2024, the salary reduced to 57 lakh, which was never questioned, and he has not given any sufficient documentation. And if we go through the documents which has been submitted in terms of assets and liabilities, he has earned 57 lakhs in post-tax in earnings for the past years. But once the order was passed by the family court on 11th November, and it was specifically told to pay the child's maintenance, all the expenses, and I have submitted all that here as well in WP 26985, as well as I have submitted all the expenses in the family court. Despite that, they have been non-compliant to the orders which has been passed, and they have not paid a dime towards the child's expenses, even after giving out all the related documents. That has not been taken care of. From past 14 years, I am taking care of the child without a question. I have not denied any kind of duty from my end. I have done everything whatever is required from my end. In the process, I've lost my father due to heart attack because of this, and it is continuous. The abuse now have gone legal as well. There's a legal abuse. There was physical abuse, mental abuse, now legal abuse as well by not following the court's order. So where should I go? Even after getting a clarification in the month of April, it was filed in 2022, 21. The main petition was
IA for maintenance.
IA for maintenance filed on September 22.
September 22.
My lord, the IA was filed on 3rd March 2023.
So I have filed the application, my lord, but I was done that on self as a individual party in person. Then I was advised to take help of a lawyer. When I went there with the lawyer, they have filed, because the application was missing an affidavit, they have filed affidavit.
So that's 3rd March 2023.
Yes.
So you also do not deny the fact that as on 2023, she was not working.
2021, my lord. She's admitted.
Application is 2023.
23, my lord. There's a withdrawal memo.
Huh?
There's a withdrawal memo for the IA number 3, which he's speaking of. There's a withdrawal memo of that IA being withdrawn. A new, fresh application was filed on 3rd of March 2023.
That's what I'm considering that only.
Yes.
3rd March 2023.
Yes.
She is not working.
On
even
that
according
day,
to you.
yes.
She was working in 2021.
21, yes.
Where are your the statement? Where are your expenses?
She has filed her objections in part 2, volume 2 of her objections.
Lordship, page number 81.
Her objections. Page number?
Page number 542 in the volume 2, my lord. 542. That is the updated assets and liabilities filed by the respondent. The expenses are in part 3 of the assets and liabilities. That is page number 3 of the assets and liabilities. Serial number 37, details of expenditure on children. It states that school fees expenses are coming up to 30,000. Daycare or
One
after.
minute, let me look at it.
My lords. Further, serial number 45 in the same assets and liabilities, respondent expenses are stated.
What is 541 or your expenses?
No, no, this is the respondent expenses.
What is this EMI of the residential property?
Sorry, my lord.
What is this EMI of the deponent?
This is the
I'm not sure.
I'm looking at 541.
541 is the respondent's assets and liabilities. That's the page number I've been given.
It starts, it is style annexure A, monthly and annual expenses as on 6/7/2023. Is it what?
Oh, that's the next page. In that case, that's the next page, my lord. The page numbers have not been written over here. Next page.
Then
Page
whose expenditure?
That is the petitioners. That is the petitioners. Part 3, serial number 37.
No, when you are at home, what is this after school care?
That is for just once. If you can help me, which
Come to
year you are
544.
referring? Sorry, Lordship.
544.
5. That was earlier. Now I am not putting him there. So I've given the 10 years expense also earlier. There you will see a difference.
You have your own house or you stay in a rented house?
I am staying with my brother. I don't have a house right now.
My lords, point number 45 in the same assets and liabilities. Statement of expenditure of the respondent. Monthly rent is 30,000 over there.
He is bearing the expenses for me. Right now, I don't have a job. Where do I stay? So we were taking care of my father as well. He was in hospital for 10 months.
No, this is a matter of 2022. Currently, there are no expenses apart from the child.
How
The
will
child.
apart from the school expenses and all, how will they live? He has to live somewhere. For that, they have to take a house.
Correct.
House has to.
For
they
the
have to pay rent
child,
for that.
my lord, for that she's equally capable as of the petitioner.
That
She's
we will
equally
see.
independent.
That we will see. That we will see. Where are her expenses?
Page number, serial number 45 of the assets and liabilities. Part 5.
Please come. Agreed with order passed in. I number 6 in MC number 6189 of 2021.
Lordship, may I speak for a moment here? Kindly consider that the petitioner has not been supporting us from past 14 years and never ever voluntarily expected to do anything. Even when they expect me to do everything, the same expectation goes with them. So right now, with the compensation what he is getting, he is hiding and concealing that data also. On 7th April, after I put up that word to Justice Pradeep Singh Yadut, there it was told, and I was given, I have highlighted that last time as well, that I was not given the entire information. And then the council has provided this information. 23, this document was submitted in the lower court, but I was not given this document. I was given on 17th April only.
My lords, if I may.
And it has impacted the order.
2021. Dated. (11/11/2024). Parties are referred to as wife and husband and wife for the sake of convenience. The wife is represented before this court, has appeared before this court as a party in person. She has filed an application under Section 24 of the Hindu Marriage Act, seeking for direction to pay an amount of rupees 2 lakhs per month as interim maintenance to herself and the child, and to rupees 50,000 towards the litigation expenses. The court, by order impugned, had granted an amount of rupees 50,000 per month as maintenance to the respondent and the child, and to meet the entire education, medical, and other expenses of the child during pendency of the proceedings from the date of application, all till the respondent fetch suitable job, whichever is earlier. While passing the order, the court has observed that as on till she was receiving the salary as per the statement till 5/8/2021. The petition is filed on 3rd March 2023. As on that day, the wife is unemployed and she has no independent source of income. But the fact is that she is well qualified and she is capable of fetching suitable job and having ability to maintain herself is an undisputed fact. The records placed before the court shows that even before the service of notice to the respondents, she quit the job and failed to assign satisfactory explanation for quitting the job.
Lordship, may I say something really here? Sorry. For any exit of an organization, it takes 2 to 3 months to exit an organization. I met with an accident, that's why I could not return to work.
I'm only extracting what is there in the order.
I understood that.
I'm not giving any finding on that.
I just want that to be considered because that I have told earlier as well, but not considered at all.
The documents produced by the wife shows the fee structure of the school in which the son is studying. Since the wife is unemployed, the husband bound to contribute for the maintenance of the wife and the child till she fetches the job. The husband is also bound to contribute for the medical, educational, and other expenses of the child, and also provide shelter for them. Even if the respondent, even if the wife fetched the job, even then the husband is bound to contribute proportionally for the main quit the job to set her score against the husband. The husband is having sufficient income to contribute for the maintenance of his wife and the child to meet their needs, and the husband is bound to accommodate the wife and the child in the same standard of living in which he is leading his life. The the court has also observed that the entire affidavit of assets and liabilities of the husband has to be taken into consideration to draw inference about the standard of his living. And in those circumstances, the court had granted an amount of rupees 50,000 as maintenance. Next paragraph. Learned counsel appearing for the husband submits that the wife, there is no dispute about the fact that wife was working till 2021, and also the material on record discloses the salary which she is earning. Then why she is not doing the job from 2021? The court has also observed that no explanation is forthcoming. It is submitted that as far as the child is concerned, the husband is ready to take care of him. But as far as the wife is concerned, the husband need not support her when she is qualified and she is capable of getting a job. It is submitted that the wife had resigned the job, has left the job, is to claim the maintenance from the husband. It is submitted that the court an amount of 50,000 as maintenance, and the order impugned needs to be set aside. Anything else? The party in person submits that the husband at any point of time. It is submitted that she is staying along with the brother. Earlier, the father is no more now. Earlier, the brother used to take care of, earlier father and the brother used to take care of her, and the father is no more, and now she has to depend upon depending upon her brother to take care of her necessities as well the necessities of the child. It is submitted that she is staying along with her. She is staying in the brother's residence. The income of the husband, as per the IT return, it is submitted that the husband is having sufficient income to maintain the wife and the child. Further, the court had only granted 50,000, and there are no grounds to interfere with the well-considered order passed by the court. Expert, having heard the counsel for the petitioner and the party in person, peruse the material on record. The admitted facts in this case are, as per the to 4,86,851 per month. The annual slip, pay slip, the pay slip for the month of April 2024 to July 2024 reflects his annual income. And there is also no dispute that till August 2021, the wife was earning and drawing salary of 2 lakh and odd. It is a case of the wife that because of her health reasons and as she has to take care of the child, she is not working, and also with the gap, she could not secure a job. It is a case of the husband that when she is capable of capable of earning, why she is not, and she should have secured the job, and she should not depend upon the husband for her expenses. It is also an undisputed fact that the husband was never contributing anything to the child from the day they have separated. And the court had rightly discussed and observed that the wife is capable of earning and she should also get a job. And as of now, she is unemployed. The court has to look at the financial condition of the parties and the income of the husband and other surrounding circumstances. Undoubtedly, in this case, the father has failed to take care of the child. Coming to the mother, this court, considering the discretion that is made by the court, the wife has to look for a job, and forever she cannot depend upon the husband. The child is also not so, is aged about 13 years. It is not that she cannot do the job. Now he is capable of taking care of himself in the absence of the mother. And the court had rightly considered this aspect and had granted the maintenance till the wife gets a job as far as her maintenance is concerned. When it comes to the husband, it is a responsibility of the husband to contribute for the needs of the boy. If the mother is working, then they would be sharing the responsibility. But in this case, as a mother is not working and the father is working and earning sufficiently, court had passed a reasoned order granting maintenance of an amount of rupees 50,000 and directing the father to meet the entire education, medical and other expenses during the pendency of the proceedings from the date of application or till the wife fetch a suitable job, whichever is earlier, and also 25,000 towards the one-time litigation expenses. Looking at the financial condition of the husband and that the wife is unemployed and the boy is 13 years age, looking at his educational and other requirements, court has passed a reasoned order and this court finds no reasons to interfere.
Till number 26, Pesh Prasad, Petitioner, Sanjay Nayak.
Thank you.
What happened?
It was not custody of the child, it was only visitation rights.
The father is permitted to have the visitation on 28/6/2020.
He went for the mediation
between 3 to 4 p.m. under the supervision of the mother at the station room as per the so-and-so. There shall be absolute cooperation. How it went on?
It went on very smoothly. And
How old is he?
4 years old.
When did you last see him? Or when the parties were separated?
23. The child was 1.5 years old.
Let's see the impugned order.
Lordship, before your Lordship sees that, my learned friend says that the child was crying and he did not go to his father. Can I just show this video to this court? This is the video of what happened on Saturday. And the child and the father is carrying the child and they're playing around together for 1 hour. And there were 3 videos of this one. I knew exactly that such a mission. Please record. Please tell the court the truth what happened.
Please show it to your client.
Please tell. It's not 1 hour. It's not 1 hour. It's about 3 videos.
4 years boy, how will anybody compel him to do what you want him to do? So what is to be done? No. What is the interim order? Or what is the IA?
IA is at page 62.
Let him say he is the petitioner. Yes. The petitioner is entitled to have visitation rights on first and third Saturday of every month from 3 p.m. to 5:30 p.m. under the supervision of mother at a visitation room. Why you have come before this court?
This court that is the type of last night according to the arbitral portion. This is the prior of the arbitral portion. A number 6 filed by the father and MC number 431 of 2022 is allowed in part. Page 24. 24. The petitioner is entitled to have the visitation dates on 1st and 3rd September, Saturday, every month from 3 p.m. to 5:30 p.m. under the supervision of mother at visitation room of family court private. However, he is not permitted to take his son outside the court. The next the prayer was not in the application. The petitioner is entitled to visit his son on his son's birthday from 5 p.m. to 7 p.m. in the public utility for the residence of the respondent and supervision. The prayer is of this was not to prior the application. That's one thing. Now, the main reason.
You are for the mother.
Yes, sir. The main reason I left matrimonial house with this child in the father is having mental instability and disorder. He's subject to schizophrenia. He's taking medication for schizophrenia. This was not disclosed to me at the time of marriage document. Then I came to know, I settled with the legal judge. Subsequently, it aggravated and was an inpatient in the hospital from inpatient in the hospital producing this document.
You can tell from when to when.
In Marga Hospital, he was an inpatient from 25/10/2023 to 15/11/2023. During this time also, even after this time, all by the petitioner, the incident claiming medicine, he was not taking. His behavior was aggravated more and more. There was an advice that he was brought back to the home. There was a continuum. When we started to show at the respondent and started to try to assert the petitioner, and started to highlight the child. Then at that time, I vacated the matrimonial house on 4/2023.
What is the modification you want from this order?
The reason I left the house is that keeping the child in weakness, taking out of the house. Now the rights are not given. One is that the burden is not been asked for. That has been. The other thing is that not for visiting that has been modified.
Wow. So how to modify it? What you want?
If you have come to one document, page number. 71.
No, it is happening in the mediation center under supervision. What is the threat to you? Page number?
71.
71, sir. 71.
There is no 71.
There is no 71 only.
There is a notice.
Yes.
Notice.
Not there in this page. What
Yes,
call?
read.
This one, this is affidavit.
You should have noticed the form 12 of CPC calling upon the respondent hearing to produce the medical records from 2015 to 2018, like body checkups, scanning, diagnosis reports, present in status.
No, Mr. Counsel, now please tell the court what has happened on the last occasion. How the child is put to any kind of inconvenience. Was he behaving badly or what has happened?
He was not behaving badly.
Then-
The child was refusing to meet his respondent. He was not, he didn't behave.
Let the child understand once, if like how the orders have been passed.
Even to this second is taking this medicine for pneumonia. So
Nothing.
still having that medical.
No, he is taking that, I understand. No,
If something happens.
what happens? There are so many people, that's in the mediation center.
There is a police over there. There's a counselor over there.
Complete
There is video
supervision is
cameras over there.
happening. Will not consider all that. This even as far as this is concerned, 5 to 7 PM in any public place, whatever it is.
So what? I asked the visitation rights on his birthday, my own one son.
No, his birthday also like not under supervision somewhere.
Let it be super. I have no problem. As long as I'm permitted to meet the child, I have no problem. Even if it is the court premises, I'll meet it. Okay, let it be in the morning time. I have no problem. As long as I can meet my son, I have no problem.
Even if court exercising a parent pater jurisdiction can pass orders, nothing, no, there is nothing wrong.
Lordship, kindly see.
That's
The
what
child, Lordship will kindly just see this video for 1 minute. Just see the video.
agreed with orders passed in I number 6 in MC number 431 of 2024 dated 29th April 2025, whereby the court had granted registration on first and third Saturday of every month from 3 PM to 5:30 PM under the supervision of mother at Visitation Room of Family Court, Bangalore, and also
Page number 5 of the that after is the court has observed. Page number 24.
I will look into that. I'm coming to that. And also granted registration on son's birthday from 5 PM to 7 PM in any public place near the residence of the respondent under her supervision and with prior intimation to the mother. The mother is aggrieved by such order. When the matter came up on the last occasion on 23/6/2025, this court has passed an order permitting the father to have the visitation on 28/6/2025 between 3 to 4 PM under the supervision of the mother at the visitation room of Family Court, Bangalore. And it is also directed that there shall be absolute cooperation of the mother in complying with the order of this court. Today, when the matter came up, learned counsel appearing for the mother submits that the child was not comfortable going to the father, and the learned counsel appearing for the father submits that the child has played well with the father and he is comfortable. Learned counsel appearing for the father, the family court before that, the family court, while granting custody to the father,
Visitation rights.
while granting the visitation to the father, the husband has further, it is submitted by the husband that he has developed major depressive disorder and constantly taking medical treatment.
No, that was at that point of time, Lordship. Now he is completely free of all those things.
I am only recording
sorry.
the order taking medical treatment. It appears that in the present situation of the husband, he is not in a position to take care of his son if temporary custody of the child is granted in his favor. And the court observes that he is none other than the biological father of the child, aged 3/4 years, and is having every right to spend quality time with his son. Similarly, the kid is also in need of love and affection of both the parents. Hence, it's not proper to deny the visitation, and accordingly granted the visitation as well, a visitation on the birthday of the child. Then counsel appearing for the mother submits that the father is suffering with schizophrenia, and it is not in the interest of the child. For that reason, the mother has to come out of the house. It is also submitted that spending the time on the son's birthday was never asked for, and the court, without there being any application, there being any prayer, had granted the same. It is submitted that considering the health condition of the father, the court ought not to have passed this order, and the order impugn needs to be set aside. Then counsel appearing for the respondent father submits that the father was taking treatment. Now he is absolutely fine, and in fact the visitation went on well. It is further submitted that when the visitation is happening, in the visitation room, under the supervision of the mother. The mother cannot have any apprehension. It is submitted that there are no grounds to interfere. Next part, having heard so and so, so and so. The husband himself has submitted before the court that he was having,
He was having.
uh,
Not schizophrenia, not
has
schizophrenia and all
developed-
that.
He submitted that he has developed a major depressive disorder.
Not schizophrenia is a totally different case. Your Lordship.
I said
Yeah, no, it's okay. It's okay. It's okay. Sorry.
major depressive disorder and constantly taking medical treatment. According to the learned counsel for the petitioner, at this point of time, he is good. He is feeling better, and he has come out of the problem. The same is denied with the learned counsel appearing for the wife. I am referring to them as husband and wife. It is denied with the learned counsel appearing for the wife. The order that is passed without even going into the merits of the matter, what is the state of mind or how the husband and the condition as of now. An order that is passed for the court is a recent order. Court had only permitted the father to have the visitation under the supervision of the mother at the visitation room of Family Court, Bangalore. For this, the mother cannot have any she cannot have any problem with this order, because as under the constant supervision and in the visitation room, and the counselor will also be present. If anything happens, that will be recorded and will be placed before the court. Then coming to the second limb of the order, that the son's birthday can be celebrated from 5 p.m. to 7 p.m. in any public place near the residence of the respondent under the supervision. Considering the apprehensions that are raised by the petitioner, this part of the order, this court deems it appropriate to modify. And even on the birthday also, he can spend time between 3 to 5:30 p.m. in the visitation room of the family court. Accordingly,
In case if it's a holiday by any chance, then the next day or something like that.
if it is a holiday, then in the next working day, he can spend the time in the visitation hall between very same time. Accordingly,
Why are you depriving the father of the son? I cannot understand.
he has every right to request.
No, I'm just
Court
telling-
will consider.
No, I'm just
I have
telling-
already dictated the order. Yes, next. Yes, next.
Still, 27. Narayan Mayer.
Yes.
27 Narayan Mayer.
Yes.
Respondent, Lord.
Impugned order at annexure E.
Modify. Partly allowed. Disposal.
Petitioners challenge the impugned order at annexure E, my lords, page number 61.
Page number?
61, annexure E.
Hmm.
My lords, in the last date of hearing, it is submitted before lordship, and your lordship was pleased to order for hand summons, and same has been served to the respondent. The contention of the petition is that, my lords, yes, no doubt the maintenance application filed by the wife in the year 2019. But in fact, my lords, the GNWC is filed by the petitioner, the husband area, seeking the custody of the child itself, girl child, my lords. And in the statements of objection filed by the respondent in the GNWC, my lords, there is no specific allegation so as to why the custody of the child cannot be handed over to the husband. Only one single stroke of one single line that the
Which is impugned order?
impugned order itself is that, my lords, the chief
Where is it?
annexure E, page number 62. In the only one para, my lords, as the in view of the petitioner and his counsel is continuously absent, it is necessary to pass the order under.
What the court can do?
My lords, the fact is that, my lords, earlier hearing also it is submitted by your lordship is that,
Have you
my lords,
filed your statement of assets and liabilities?
sorry, my lords.
Your statement of
No, my
assets-
lords, the very fact
Why you have not filed?
that is the contention taken before your lordship is that the, my lords, advocate before in the GNWC, advocate appearing for the petitioner therein, the present petitioner, not at all communicated to the petitioner, continuously, my lords.
And did you give a complaint to the bar council?
My lords, even in last date of hearing on 30th.
Blame the advocate like
Yes,
that.
my lords, the necessary steps has been now been taken by the
Where is
petitioner.
that affidavit filed in support of this IA?
My lords, the last date of hearing on 30th before the family court, my lords, the petitioner has submitted an affidavit to the judge, family judge, requesting to change the advocate. But the family judge that directed the petitioner to take a proper necessary steps by issuing a notice to the advocate and thereafter request for the change of advocate. And now the trial court, family court has issued NBW against the petitioner and fixed the date for the hearing on 5th of this month. That is on next.
So what is your income?
My income is that, my lords, it is been stated that 30 to 40,000. I am working in Andhra Pradesh. My family is situated in.
Is 40,000. Who are the petitioners?
Petitioner is the husband.
Not petitioner, like who sought for the interim maintenance?
Respondent wife.
Only wife.
Yes, my lords.
What is wife doing?
Wife is working in on lordship.
Their contention, she is working as a beautician in a
beauty parlor. Lordship.
How much she is earning?
She is earning 6,000. Monthly earning is 6,000.
How much the court has granted?
Court has granted 10,000 for wife, 5,000 for.
There is a child also.
Child also.
Lords, we sought for the custody of the child. GNWC is filed by the petitioner himself.
So if GNWC is filed, the child should be given to you and no maintenance will be paid.
My lords, apart from that, my lords, at least if the opportunity to the petitioner is afforded to defend the application itself before the trial court. No doubt there was a miscommunication and objection is not at all filed.
No, but now I'll only interfere with this order provided you what is the amount that you are ready to pay to the wife, and on that I'll set aside this order and remand.
My lord, so far as the child is concerned, I am ready to. It is the bounded duty of the father to provide for the child. That is, I understand, 100% understand.
10,000 to the child.
I'll undertake to file, take the necessary step for the child, my lords.
Pay 10,000 to the child from the date of petition till now, and whatever other things, whether wife is entitled or not, let court decide.
Please, my lords, if it is so, my lords, please. In my main prayer is also is that, my lords, I have sought for the reconsideration of the application as I was unable.
I'll ask them to reconsider.
That
And
may kindly be noted.
And on the condition it will be reconsidered. It's only the conditional order is 10,000 from the date of application till now. Whatever that amount comes, it has to be paid. Then
My lords,
only that will be.
If I may submit it to the point, so far as, my lords, as on the present calculation awarded by the trial court, it comes down to around 10 lakh 5,000, my lords. As on today, 50,000 is already paid by the petitioner before the execution court. If the child, the amount of the maintenance for the child is fixed for 10,000 from the date of application, my lords, petitioner will undertake to pay for it.
How much is that? When is the date of application?
Date of application
29,
27/11/2019. Now, till now, 66 month.
66 months.
66 months.
66 into 10, 6,60,000 would be
Please.
the amount.
Please, my lords.
When will you pay?
Lords, my difficulty is that, my lords, on 5th, the family court has fixed the date for the in the execution petition, and also NBW is issued against the petitioner. If on 3 to 4 weeks time is granted, I'll definitely pay the maintenance towards the child, my lords, and deposit before the execution court or in the GNWC court, my lords.
Or else this order will restore.
Please, my lords. I am bound to obey for the orders of the court, my lords.
Lordship, regarding wife.
No, I am not saying, because court will consider
Yes,
now,
yes,
because
yes.
it is not a recent order.
Yes.
Court will
Lordship.
consider. I'm not saying
Actually,
that
Lordship.
whether she's entitled, not entitled, nothing I'm saying.
Lordship, kindly appreciate the entire RTC discloses none appear.
Correct.
Then your Honor, Lordship, kindly appreciate.
He has his
In
own-
execution
Point to be-
proceeding also,
My
in
lordship,
execution proceeding also, he did not raise your.
In your client will receive the money. That is also important.
Yes.
My lords, one more point to be considered is that, my lords, prior to passing of the order, impugned order, there was a point wherein the trial court has taken, family court has taken the point that as the petitioner and his advocate is absent, their objection to the IA number 5 is taken as nil. Subsequent to that order, my lords, it was.
Not appearing before the court, you cannot afford
Yes,
to
yes, my
submit
lords, yes,
any
my lords.
argument before the court. Just leave it there.
Please, my lords.
The agreed with the orders passed by the family court family court dated 5/6/2023 in I number
IA number 5, my lords.
I number 5 in GNWC number 142 of 2018 dated 5/6/2023. The husband is before this court. The respondent wife had filed an IA seeking, husband has filed GNWC 142 of 2018 for custody.
Yes, my lords.
And their wife had filed an IA for the maintenance. That IA, in that IA, the husband has not filed his, no, instead of husband, say father. Father has not filed. Where is the maintenance for the wife in GNWC?
Actually, yes, Lordship, that is a question of law because he has deserted the wife and
No, why GNWC, how will you see?
GNWC
What
filed
is
by
the
the
question?
GNWC filed by the husband that
Correct.
discloses he
So
deserted
why
the.
if wife maintenance, why it will be considered in GNWC? I can understand the child's maintenance.
That's kindly, that is questionable because.
No questionable.
Because Lordship.
You have your own remedy.
Admittedly.
Go to the under 125 CRPC proceeding or some other proceedings. You can initiate.
Admittedly, since 2017, she has deserted.
Waste of court's time to decide that also. GNWC, what is vice maintenance? What did you write? The wife has filed an IA seeking maintenance for herself and for the child. The court had, as the husband remains to be absent continuously and has failed to appear, court had granted 10,000 maintenance to the wife and 5,000 to the child, who is aged about?
Who is aged about
14 years. 14 years.
14 years.
Who is aged about 14 years. When counsel appearing for the petitioner submits that the counsel who appeared before the court has not informed the party about the developments in the court. As such, he could not appear before the court. It is submitted that in the GNWC proceedings, the wife cannot seek any maintenance. It is only the child who is entitled for the maintenance basing on the facts of the case. It is submitted that court, without giving an opportunity, had granted maintenance of 10,000 to the wife and 5,000. As far as the boy is concerned, he has a responsibility to take care and he will be taking care of the interests of the boy. Land counsel appearing for the respondent mother submits that continuously the father was absent. Even in the execution also he was absent.
No, my lords, in execution he is present. He is appeared through advocate, and now in the last date of hearing, he was brought to the court.
Contention, let him.
Please.
He was also absent, and he was not pursuing the matter diligently. An order passed on 5/6/2023 is questioned now. When the question now and is questioned now, he submits that no interference is called for. Next for having heard so and so. There is a material on record. As rightly argued with the counsel of the petitioner, the wife cannot file an application for her maintenance in a GNWC case filed by the husband. And as well, it's a responsibility of the husband to take care of the necessities of the child. This GNWC is filed in the year 2018. When he's seeking the custody, he should as well thought about the requirements of the boy and should have taken the responsibility. The reason that he stated that the advocate has not informed him about the developments, as such he has not appeared before the court. This court is not able to appreciate the said contention. But at the same time, in this case, the court had awarded maintenance to the wife also. Considering all this, this court deems it appropriate to set aside this order on the condition that the husband shall pay an amount of rupees 10,000 was the maintenance of the boy from the date of petition till today, and shall continue to pay till the IA number 5 is decided by the court. It is submitted that the amount comes to 6,60,000. In that he has paid 50,000 in the EP, in the execution.
Yes, my lord, I already deposited
50,000. So the remaining amount is 6,10,000, and that should be paid within a period of 4 weeks from the date of receipt of the copy of the order, or else the order will be revived and the respondent are at liberty to proceed with the execution.
Lord sir, the execution court has fixed the date for the execution on 5th of this month, my lord. That is on Saturday. As on that day, at
Order
least.
has gone.
Yes, my lord.
It will also go.
Please, my lord. That observation may kindly be noted. As on that day, at least the petition may kindly be, the order may be not that
necessary. You will get this copy by tomorrow.
Please, my lord. Much obliged.
Till number 28.
In priority. Type that.
Cell number 28.
Yes.
Petitioner in the first matter, my lord. Lord, the first matter, there are two orders that have been challenged. One is with regards.
No, why
to-
is it adjourned on the last
No,
occasion?
it is adjourned because with regards to the maintenance, there was a discussion that is going on and your lordship suggested certain things, whether we can adhere to paying 20 instead of going back remanding the matter. Because now we have filed an application for modification of the maintenance order because there's changed circumstances of his job, my lord. And his salary, that he's getting half the salary what she's drawing. And last occasion, your lordship had directed them to file what are the maintenance that they have, what are the expenses that are incurred to them.
Where are they? Fine.
Let's also, your lordship had directed that if they withdraw that application which they have filed, and this would be made, I have filed it on the, on 30th June itself and
2025, open court it has been filed. Now, I took time to verify this, my lord, and I'm filing
I'm
my-
sorry that I just complete.
I'm just filing a synopsis of what they have stated, nothing more than what they are saying, just to say. Lord, they have produced a lot of screenshots saying this is the payment that they have made. Lord, so far, whatever claim that they have made, I've just made an analysis, my lord. Now, from the date of the order, from the time she's left the home, what is the amount that has been claimed and what has been paid? After she left the home, my lord, school fees was 2,71,000. Then for third standard, 1,71,000.
Where are you reading that?
My lord, I am just this.
Yes, that is first page. It starts with school fee for the second standard.
Second page, my lord. The tabular column, my lord.
Yes, I'm looking
Please,
at
my
that.
lord. Please, my lord. Lord, they have filed, my lord, I have produced two. Today they have produced this. From this, last occasion they have produced. That includes what are the expenses. They did not specify under what headings they are incurring the expenses or what are the needs of the child. That's what your lordship had directed them to place, or what is the needs of the child. My lord, now is a situation where we are concerned about what is the needs of the child and then what should be the proportionately what each parent should pay. Now, they have filed only education and extracurricular activities, whatever the expenses are. On that basis, my lord, I have just made an analysis of what they are claiming. They say school fees is one component, not in the current document, item number 5 and 6. Item number 5 and 6, the tabular column, my lord, 2,08,500 rupees is the fees. I have no objections, my lord, and we will pay this amount. They filed it here, which they usually would have filed in the family court. I've advised him to pay the amount, which will pay it in the court. It will be recorded in the file, my lord. Now, coming to the second expenses which they are doing.
Where are you reading? You see in your column, it is like school fees for second standard, 2,71,816.
Please, my lord.
School fees for third standard, 1,71,900. That's what I'm looking at.
Please, my lord.
That's all. Then you said something like 2,08,000.
Next page, my lord. The lordship may kindly flip the next page. Now, all this up to number 4, we have paid whatever they have claimed. That's also being challenged here, my lord. When we say in our objections, we have said, now 20,000 rupees the court has awarded for maintenance. School fees, I'm paying 50-50. Apart from that, what are our other expenses? Over and above that, she files it in the court and we have paid, though under protest, we have paid that it has to be taken from the 20,000 rupees. She's now making a claim here. Now, my lord, in item number 5, column number 5, my lord, today out of the document which is produced on 36, 2,08,500 rupees is the school fees they're saying that will be paid. Next, additional expenses according to them, uniform, books, bags, 20,000, transportation, extracurricular activities, 48,000, the school fees, chess, cricket, table tennis. These are the expenses that they are saying they're incurring. 68,000 is what they have spent from August 2024 to June 2025.
So like 2,08,000 plus this.
Plus this is what they say. Previously also the same thing, my lord. Every year there's a school fees and then additional expenses. My first submission, my lord, is that these expenses, even if I admitting without disputing them, saying that my first submission would be, my lord, that it should be taken from 20,000 rupees, which has been awarded. All these expenses should be taken there.
Secondly, my lord, this amount, if we take, now 50% I'll have to pay, 60,000, 68,000, 2,40,000 I am paying per year. Out of that, my lord, even if you take this, comes to 5 to 6,000 rupees a month. 60,000 rupees divided by 12, if you go, it will be about 5,000 a month. So assuming that 5,000 from the 20,000 which I am paying, as a father he is paying for the child, 5,000 goes, 3/4 of the amount remains for the child's expenses. That's 15,000 rupees. Child's maintenance. So my submission would be, my lord, that this amount has to be paid from that amount and not add additionally onto him at this stage where previously we have disputed it. I have filed in my.
Where is your wife residing?
In Koramangala, Bangalore. Both of them are in Bangalore.
She has her own house.
She stays with her parents in their own house. They're better positioned financially as compared to the father here. The kind of house that he stays is a middle income MIG home. It's an apartment, and this is an independent house. It's a bungalow. But she's staying with her parents, and the school is also elite place where they're residing. It's also school is also an elite school. But so far as the child's education is concerned, I am paying that amount. Now 20,000 which is ordered, it includes all these expenses. Now I have been saddled with additional amount. So when last 2 occasions I paid, I said under protest I am paying this.
You paid this 68,845.
Half of it I have to pay, my lord.
You paid.
No, my lord. This is produced only today. On 36 it was given to us. They have not produced to the court. So far they have not produced. Now they are asking for
according to you, half of it should be used from your 20,000.
20,000. These additional expenses. That is the first submission, my lord. Now coming to the question, my lord, now whether what should be your lordship asked, whether we can fix instead of going for a re-inquiry on my application for reduction, considering the his salary has been reduced to 75,000, his take-home salary 67,500 rupees. And now I'm paying in all about 4 lakh rupees, which comes to about 40-50%, 45% to 50% of my salary which I'm taking. She is earning 1.4. My lord, in regarding her statements, my lord, she has not produced her appointment letter. She has not produced her bank statements completely are not produced. We have also raised all these objections before the family court saying that her assets and liabilities are not complete in it. She has mutual funds. She has FDs more than 20-30 lakh rupees is with her. Now my statements are looked into and saying this is what I have the means and I'll have to pay is what they're saying. My lord, I have now if she has produced, she has made claim, she should have been transparent. Now we have said in the council tried to say that in our assets and liabilities, we have said that 1,16,000 rupees is a salary. That is a statement she made. I have gone by the statement, but I have also in my objections said that she has not produced. I don't know what salary she's getting. Whether she's getting any other amount, she's in marketing field, she will be getting in incentives. They are suppressing this information. Now, if now proportionately she's drawing double. One, there is suppression of information. She's drawing more salary from me than me. Now, whatever is being paid would be adequate to take care of all the expenses for the child, and that should include all these additional expenses. Now they have filed it in this manner. I just made a summary so it becomes easy for me to explain to your lordships, my lord, the payments. We don't even know for whom these payments are made, but I will accept that the screenshots are sent, my lord, Usha Rohini, we don't know who they are. However, in the first page they say the payments are towards cricket and chess, so abacus. So on that score, my lord, though we don't know who they are, we will say that yes, we will accept this amount, then it should go from that. That is my submission, my lord. Yes. And my lord, now the question is that is this the statement they make as what is the needs of the child? This is only with regards to the educational and extracurricular expenses is what they're saying. Housing, food, clothing. When all of us live together in my house, we spend not more than 20,000 rupees is my statement of objections before the family court as regard the maintenance. That is a lifestyle that we have had, and that is the expenses that's actually incurred for 3 people. Now for one child, 15,000 rupees, leaving out these expenses would be adequate. Now in order to cut short going there again, asking for reduction, your lordship asked us whether he would be willing to pay. we agreed or consented on your lordship's suggestion that yes, it can be paid, provided that there shall be no enhancement or no claims. School fees gets increasing, my lord. I will be paying that amount. Whereas this amount would be adequate because she is earning and now otherwise I will say that it should be, let us now say this is the expenses for the child. Let it be proportionately fixed according to our means. This is my respectful submission.
Yes.
Let's, first of all, it is 1,16,000 and it is not 1,40,000 as they say. In fact, my own affidavit, I am ready to produce the bank statement. It is not increased more than 2,000. I think she would be getting 1,18,000 if I'm not mistaken. I am ready to produce that also. But that apart, your lordship had rightly suggested if they will withdraw that application which they have filed, because they are saying that they have lost the job and now he's got a job which is paying lesser. Though I did point out to your lordship, even in that Let's Doc startup that he has joined, there 3 lakh is what he is earning and now it has come to 75. Like I said, I think very soon he will say I'm earning 50 and then 25 and then he will say I have no job at all. Yes, I definitely leave it to your lordship. If they are saying they will withdraw that application and continue to bear the educational expenses, all that I said is proportionate. He could have paid a little more, which they were not okay. And he's continuing, whatever expenses that he's continuing to bear, let him continue that, my lords. Apart from the 20,000, I'm talking about whatever he's paying. Let him continue with that. I know this thing. Twice in a month, which your lordship had already said, from Saturday evening they wanted instead of Friday, Saturday evening to Sunday evening. I'm okay with that, my lords.
My lord, as I said, my lord,
I think that already we had argued and that was.
The 20,000 is confirmed, my lord, because we have said, if we have protested in our objections also, my lord, even in the.
Yes, it is under protest. They have said, I'm not saying
that
yes.
Additional expenses should come from the 20,000 rupees. Now, now we don't know what other expenses would come in. But when the child is with me, and whatever expenses I will have to bear, I will bear. I will have to pay for the child or whatever. Child is my child also, not only her child. So I will pay for the child. So that child's education also we will not come in the way, my lord. But the question is that the school that he was studying earlier was 60,000 per annum. Now it's 1 lakh, nearly 2 lakh rupees.
No, this expenses you already paid.
No, my lords, from past 1 year, that is the memo I filed. They have not paid at all. Last year, on the last.
You were saying, whatever he is paying, he shall continue to pay.
Continue to.
What he paid till now?
My lords, till August 2024.
Last year, this column which I have produced, my lord,
apart from
item number 2 and 4, additional expenses which are there.
Lords, apart from the educational expenses.
Please, my lord, that 66,000 and item number 2, the column number and the serial number 2 and 60,000 serial number 4, 50% I have paid, my lord. So that they say I should continue to pay.
That no, like this is all like pertaining to the child.
Educational expense.
I can understand like some other things like any other expenses, but this is a part of the school expenses.
Exactly.
Only.
School. The chess school
van,
the only thing, my lord,
school cricket coaching, swimming classes.
My lord, it's only the request is 20,000 should encompass even this, my lord. It should come from there. Other expenses, that school education fees I am paying. Whatever is the fees, my lord. The 2 lakh rupees, your lordship may kindly see 1,71,000.
Uniform, books and bag is also part of the school. That's 17,498.
In a year, it hardly comes.
That is what. That's then what. Then school van, chess class. This is a recurring expenditure, and that 20,000 what you give, how will it be sufficient? And from Monday to Friday, everything she is taking care of.
I leave it to your lordships, my lord.
So what we do is whatever you are paying, let it be, and their enhancement is dismissed, and you have also undertaken that you will also withdraw that. Modification. And from Friday?
Not Friday, no, they wanted Saturday
morning?
No, Saturday evening to Sunday evening is what was decided already. 6 p.m. to 6 p.m. is what they wanted.
Little later, my lord, because he plays cricket with me. But I need to go drop the child. All this will be up to 8 o'clock.
On Monday he has to go to school.
Go to school. That is the reason this timing was decided.
Today Sunday 8 o'clock. Then let me pick the child earlier. On
When-
Saturday, on
Friday
Saturday.
you can, Saturday
Saturday,
whenever
I may pick the child earlier. The child does not have school on Saturday. I'll pick the child earlier and drop.
Plus,
by 6 o'clock.
in fact,
Saturday afternoon
plus
after
may I
lunch.
just suggest, in fact, this timing, my lords, after considering that finishing the homework and the mother also will have, that is the reason, it can be 5 o'clock, 5:30, or I'll tell her, she's not a person who is this thing, I'll tell her to message him whenever he's free, he can come and pick up the child. I don't think,
I wasn't.
no, I was, sorry, I was just submitting to the court that let it be 6 to 6. She is not a person who creates any issues because she herself 50% she has agreed. I'll tell her as soon as the child is free,
No,
she can be.
4 o'clock you can take. Play cricket on Saturday. Sunday by 5 o'clock, let the boy be sent because he has to, because next day he has to, active for Monday. And so that he'll sleep early also. What's the age?
Age is 10 years, he'll be 11. He's going to be 11.
4 o'clock on Saturday.
4 o'clock on Saturday, 6 o'clock on Sunday.
Not every week. That was already set. Twice in a month is already.
What is asked?
Because they have asked Friday to Sunday every
No,
week.
that is what you suggested.
No, they have asked Friday
No,
to
they
Sunday.
they are asking every week.
Correct.
You suggested let it be twice in a month.
Because actually that was earlier itself, actually that was, lots sorted out because though she said, I'm okay for once in a month, I said, let it be twice in a month.
What is happening now? This is a overnight custody. Otherwise, when he is having custody?
Morning to evening on Sundays.
Sunday morning to Sunday.
Sunday morning to evening. That's all. No overnight, my lords. That is the reason I said, let him take twice in a month.
Because mother is also working.
No, she has from Friday evening, this child gets back home, then Saturday evening, the child, she has 1 day. She has 1 day, I have 1 day, that's what your lordship suggested, Then that's the question, or we are happy sharing it 50%.
Lots, twice in a month is, I would, because otherwise it will be an issue for me. That is the reason.
Then we will say something like this.
Lots.
We'll do something like this. Alternate 2 weeks, let him have the overnight custody, and other 2 weeks, let him have.
Let it continue
let him
Sunday
have the
morning to evening.
custody.
That's
Like,
all right.
Sunday morning to evening.
That's okay.
No.
She's taking.
Now, first of all, the court has not passed any overnight custody till now. Now the court is summer vacation. No, that's why. No. In this four Sundays on 4 Sundays, 2 Sundays Monday morning to evening, and 2 Saturdays from 2 weeks Saturday to Sunday.
First and third Saturday, my lords, or second, whichever they are convenient.
She has a Friday, 1 day she has, and 1 day I have, the child is sharing. Child is happy to come with us.
Agreed with her.
But apart from this, the child has 70 school holidays. Now we have Muharram coming in, the Ramadan festival coming in. That will be holiday.
No,
regards that, can they file?
Why it was not decided? Why do you want to again another round of litigation?
My lords, that is the reason, my lords, if your lordship recollects, it was in the chambers, and I said this issue can be, a joint memo can be filed, we'll arrive at something, but they never agreed. This is exactly why another round of, this is one. Plus, this issue can't be just decided like that. I've been telling from that day to file a joint memo where she had also come, he had come, but they never agreed to that.
Agreed with orders passed in I number 8 to 10.
One more aspect, in I8, we have sought for that was order is not I sought for access. Now, attend school parent teacher meeting and other social activities which are that will be tolerated. The access to the portal and for him, his name to be shown and him to get communication, that has been denied. And why it has been denied, I don't know. I asked for that.
What is the
I don't think there's an issue. Probably he must have created. I can verify that, my lords. I'm not. I don't think his name is removed. Not at all. She's not. his name, his number, everything is appearing.
We'll make it clear. The father can have the information, but the custody is with the mother. So with the school authorities or anything, he doesn't have a say.
Milords? No, there should not be any problems created near the school. Then it
No,
becomes.
it is like this. Now the custody is with the father, with the mother. Mother will only be the one who will be communicating with the school authority. He wants to have information. Let him
Definitely
have.
he can have. We are
Unless and until there is an order from the court, no communication with any of the school.
If I don't get school holidays, activities.
No, that you will get. That's what I'm saying.
Information.
That access will get. But ultimately, that is the mother who will be taking a call with regard to unless if you want anything, you can take permission from the court. Petition.
I don't talk to the authorities in any manner.
That's what I'm saying. If you don't talk, it's fine. I will only clarify that.
But now, my lord, to say that I should not be doing anything, then I'm already branded that I can't be doing it. As a father,
What will happen is, if two people with having these kind of differences, if they start, having interaction with the school or any kind of, and then one day the day will come that the child will be sent out of the school because they are not able to bear all this. So let's not give that unpleasantness to the school.
sometimes when holidays are not informed to me, then I have to.
Now I say that you will be there in the school portal, you will know everything. But ultimately, it's a mother who will have the say in the school affairs. Father cannot interfere.
But my application is necessary. Let there not be any restraint order against me rather than saying that grant me access to school portal permit me to participate in such activities.
Whenever, if you want me to pass that order, I have to clarify that. Because it creates unnecessary nuisance in the school, which is not good for the child, not to the parents. He can interact, he can know, he can go, he can talk,
yes,
but
as a father.
he cannot take any decision on behalf of the child in the school. As long as this, all this DNWC is not decided. Because that it cannot operate that way.
But so far, I have not done any of those things, number one. Number two, may not any such directions will slowly
No, I've already passed in several cases that. Because it will unnecessarily create problems. That's why the court has not granted that permission.
No, that's not what the court was arbitrarily said.
No. We'll say you can go, you can attend the parent teacher meeting. You can have an access to the portal, but with regard to the child, any decision that has to be taken, mother can only take at this point of time till that is decided. Let him know all the information, anything he wants, any particular direction. No. You can ask. No, you're not understanding what the court is saying. You can ask anything, you can interact with the teachers and everything. But when an issue comes, anything with regard to the child's activities, any information, any point of contact, that is only mother, not the father. And she will only be taking a call. Two people who are not having good relation cannot have an access to the school, and both of them take their own decision. And which the school people have to follow, what they will follow.
We will not interfere in the school activities of the child. But if there is a parent teacher meeting, I can't ask what the child.
No. What is it? You can ask. Who's stopping you from? You cannot advise the good teachers to do something which is contrary to what the mother said. Yes, you can go. You can go to the school, in the parent teachers meeting, go meet the teachers, but shouldn't create any kind of situation which is not unpleasant situation should not be created. No, I'm not saying that someone is bad, someone is not, because order is going to be passed in your favor. For that, I'm saying what is the order is going to be, and he has to behave in that manner.
Already the school has said that the order family court, I should not create any incident. I will not do.
Yes.
Anything that's happening.
Agreed with the orders passed by number 8 to 10 in GNWC number 349 of 2022, dated 3/4. What is the date of the order?
349 minutes. Please, Milords. There are two.
Unfortunately, even for the date also we have to search. We have to search for the date. Fortunately, it is there. Generally, we have to search. 3rd April 2024. What happens is this cause title will not be there to the orders. That is very strange.
In the order sheet, it's a separate order.
No, what happens, any IA is passed, whenever there is an order passed, the procedure what we follow is, every order will have this, the cost item.
It should have.
Otherwise, what is happening, everywhere we look, where 3, 4, which year it will not be there anyhow in the signature.
That's because in the order sheet, they make it as a part of the order sheet. That's how it happens there. The maintenance order doesn't that matter.
No, other docket proceedings is different, but when you file an IA and an order is passed, IA should have a cost title. So and so, both the mother as well as the father are before this court. Parties are referred to as the father and mother for the sake of convenience. WP number 14708 of 2024 is filed by the father, and WP 4376 of 2024 is filed by the mother. As per the order impugned, the father is permitted to make. This respondent, it means father. The father is, I think this father, petitioner, respondent, this confusion should go.
Father, mother, I think will.
Wife and husband, that is more convenient. The father is permitted to make audio, within brackets, voice calls, video calls, and talk with the child between 7 p.m. and 8 p.m. on alternative days. Further, is permitted to take interim custody of the child from 9 a.m. to 6 p.m. on every Sunday and 50% of the holidays during summer vacation, Dasra vacation, and winter vacation. And the respondent is directed to, and the father is directed to take care of the needs of the child while in his custody, and also directed not to give objectionable food, snacks, beverages to the child during his custody, and is also directed not to give any ill advice against the respondent. Then where is the in the next writ petition it is?
My maintenance is in the 4376.
Oh, so this is not against one
Not
order,
no,
two
my
different
lords.
orders.
Two separate orders.
No, I said against that order. So against the orders passed in IA number 8 to 10, the father is before this court, and Anita,
3 and 4 is.
and agreed by the orders passed in page number. Where is
Millard's page number, it starts with 135. Orders on IA number 3 and 4. Maintenance, interim maintenance plus the litigation expenses. Page 135, Millard.
Already it seems there is some order passed by this court, by one of the learned judge, that there should be an what are this
Separate orders. I think nowadays they are following that. I'm told that there is a separate order apart from this. Nowadays, I think they have inculcated that.
That one order is passed.
I've been told in family court. Apart from the order sheet, they've been doing
the writ petition WP 4376 of 2024 is filed by the mother, agreed by the orders passed in I number 3 and 4, whereby the court had granted.
Well, operative portion will be 140.
Granted an amount of rupees 20,000 towards the maintenance and 50% of the educational expenses of the child from 2021 till disposal of the petition. The learned counsel appearing for the father submits that the court had granted the visitation 50% of the custody during the holidays, and when it comes to the visitation, interim visitation, it was granted only from 9 a.m. to 6 p.m. on every Sunday. It is submitted that the boy is comfortable with the father. The court ought to have granted the custody, ought to have granted overnight custody every week to the father. It is submitted that I number 8 is filed. Where is that I number 8 affidavit?
I number 8 is for communication with.
Where is that? Is filed seeking access to the school portal and permit him to participate in the school activities. parents teacher meetings, school days, sports days,
Yeah.
school fest and such other child school activities organized at the school, organized at the school. Land council submits that the court without any reason has not the access to the school portal that the said relief was not granted by the court. However, he is permitted to participate in the school meetings without making any nuisance and affecting the future of the child. It is submitted that as the father is not having the access to the school portal, he is not able to have the complete information with regard to several aspects, and there is no basis for the court not to grant the access to the father. When counsel appearing for the mother submits that the father's then the writ petition that is filed by the mother is seeking enhancement of the amount that is granted by the court. According to the mother, when the father is earning more than the mother, the school fee, the expenses have to be borne proportionally. This court had interacted with the parties, and also the councils have made the efforts to see uh, that there is some consensus between the parties. Today, when the matter came up, then the father has already filed an IA before the court seeking modification of the order in IA number 2 and 3. Yours
No, mine is 3 and 4.
3 and 4.
Her IA recently is, I'm not sure of the modification.
Modification of IA number 3 and 4 as the father's salary. Earlier it was 3 lakhs.
335 minutes.
3 lakhs 35,000. Now it has come to now what he is getting is
35. That's exactly what I'm saying.
3 lakhs
At the
and,
time,
3 lakhs, and now what the salary is getting is 75,000. Hence, in the changed circumstances where the salary has reduced, they filed an application seeking modification of the order. Today, the counsel for the respondent mother, the counsel for the mother submits that if the father continues to pay 20,000 and 50% of the educational expenses and the payments,
extracurricular activities
the payments
related.
that are made for the extracurricular activities, if he continues to pay, they are ready to. They will not press for this writ petition, and also they shall not
Press.
Which is that one?
IA number before the family.
The modification IA that is filed, the IA that is filed seeking modification of the order.
Reduction of maintenance,
If
milords.
for maintenance, 16/1/2025 seeking modification of the earlier order for reduction of the maintenance. If they are not press, they also shouldn't press that application, and if they withdraw on those conditions, they will also not press this petition. Then counsel appearing for the father, and the father is also present before the court. It is submitted that it is acceptable to them. Then coming to the overnight visitation, the father is already having 50% of the summer vacation, custody of the child for 50% of the summer vacation, Dasra vacation, and winter vacation. But when it comes to the weekly visitation, the court had granted from 9 a.m. to 6 p.m. on every Sunday. This court deems it appropriate to grant the overnight custody on first and third Saturday between 4 and 6. The father can pick up the child at 4 o'clock on Saturday and drop the child back on 6 o'clock on Sunday. Then coming to the first and third, second and fourth Saturday, it is between 9 a.m. to 6 p.m. as fixed by the court.
agree on everything, my lord. Let the father and child have this bondage, my lord. Again.
No, he's getting, let's take it slowly.
Administration will continue because she has overnight for one Saturday per weekend, she has an hour.
Plus, in fact, the whole matter can settle, in fact. How many times I've pleaded, if he just agrees to a small variation, the whole matter can settle, in fact, my lords. Your lordship is well aware, I had brought her to the chambers. I think the mother has been very considerate that way, comparing from what I have seen of the other.
Coming to I number 8, the father, it's not 8.
8 is for.
Portal access.
No, I'm talking about
Talking
8.
about 10,
8.
it is right, my lords.
Coming to I number 8 is concerned, father shall also be included in the online portal, and father can, and mother shall include the father's name in the online portal, and so that the father will have the access to the information. The court has already passed an order that the father is permitted to participate in the school meetings without making any nuisance and affecting the future of the child, and that should continue. Accordingly, both the writ petitions are disposed. Grateful.
Very longer time on Sunday, 9 o'clock to 7 p.m.
9 o'clock.
I asked for overnight for 4
9 o'clock, 9 o'clock to 7, Sunday.
It's all right. Only thing is, sometimes what happens next day school, so that should not be disturbed. It's all right, no issues, that's okay. Grateful.
Yes, next.
Also matters, sale number 1, Manjunath ND for petitioner.
No representation in the morning and as well in the afternoon. List the matter tomorrow. Yes, next.
Sale number Sale number 6, 14%.
Three, 4, 2, 5. What is the order impugned in 3, 4, 2, 5?
Page number 116.
Disposed.
Page number 116. This was an idea on the syndicated grounds and now asked for a discussion.
For this petition, there is no urgency. We'll see later. The office objections, if any, shall be complied with by the petitioner. Next, what is the next one? 6.1. 26650. List the matter after 4 weeks. Next matter, 26650.
This matter could be disposed of, madam.
Yes,
Because this,
which one?
it's a 26650.
Yes, what is impugned order, page number?
Impugned order is continuation of the temporary injunction that was granted.
No, where is it? Where is the impugned order? Page number. Difficulty of the court is, unless and until court knows what is the writ petition, I cannot understand any of your submissions, either yours or her submission.
May
So
I
that's why
make
I always
submission in
ask you
this
for a
matter?
impugned order. Where is the impugned order in the writ petition?
May I make submission in this manner? 2 minutes, I will make it clear, Your Honor. She had filed a suit restraining me with seeking for permanent injunction. For permanent injunction, restraining the defendant and his henchmen, heirs, representatives, or anybody from any way interfering with the peaceful possession and enjoyment of the suit scheduled property by the plaintiff.
So this
For
is the
grant such
please
other
come to
relief.
page 79. Please come to 79.
Page number 91 exactly the impugned order, dated 10/9/2020.
90.
91, 91.
What is the order at 91?
I read the impugned part of the order, dated 10/9/2024.
Please read.
To the order stated 18/4/24, interim order stated 16/1/2023 was extended for 3 months. As of today, interim order stated 16/1/2023 is no. That was the order. Before that, I have filed an advance application. The court did not allow an advance application method. That is why the interim was not extended, my lord. And before, Justice Ashok, and Justice Ashok also noted that there was an error being made and the implication was being granted. And again, into the basis case, opposite advocate, they filed an affidavit saying that they will not interfere with the possession of the property till the disposal. So an order has been passed only based on their affidavit.
I have filed the affidavit. Yes, writ petition itself can be disposed of.
Dispose of.
Because
all that can't be done. All that can't be done. When you ask for an interim order, you have to stick to the interim order. There is a procedure. Whatever you ask, court cannot grant. When you are questioning this interim order, only tell the court what is the impugned order. 227 is only concerned with the order that is passed by the court. What is to be done by this court? Nothing else I will say. No, this is the order. Your grievance is your interim order is not extended. Now I'll say that interim injunction that is granted is extended.
And then there is the judgment order also passed by under same sections. Again, they consider order.
That's why I will, otherwise if you argue like that, what I'll say is, yes, I will dispose it off.
Please don't dispose, my lord.
What I will say is, if you argue like that, I will pass that you are not understanding the procedure and you cannot appear as a party in person. Not necessary, not necessary. Like this, the writ petitions cannot be kept pending. Please come.
My lord,
We can't give that prayer. That I will. Why that cannot be granted? I will pass an order. The writ petition is filed, seeking the following prayer.
my lord, one more humble submission.
Yes.
Can I just read my prayer in this petition, page number 30?
That's what I'm asking her to extract. Page number, entire prayer you extract. The order that is impugned before this court.
So my prayer, I'm asking also to mark the petitioner evidence and related evidence in English.
The that you should ask before the court, not before this court. For asking, there is a procedure to file an IA. Understand? Just like that, you can't come to, this is not a writ petition under 227. You're coming before this court questioning an order passed by the court. You cannot ask any relief for the first time before this court. That is law. That's what I'm telling you. Go before whatever that I'll tell what to be done. The present writ petition is filed, questioning an order dated 10/9/2024, wherein the court had not, had observed that through the orders dated 18/4/2024, interim order dated 16/1/2023 was extended for 3 months. As on today, interim orders dated 16/1/2023 is not in force. For want of court time, further chief examination of PW1 deferred to 29/10/2024 and directed the matter to be called along with MC number 3129 of 2023 and MC number 209 of 2022 and criminal miscellaneous number 592 of 2023. The petitioner has filed a suit. The petitioner, who is the plaintiff, the party in person, who is the plaintiff in the suit, had filed a suit seeking injunction,
Permanent injunction.
seeking permanent injunction in respect of the suit scheduled property by order dated 16/1/2023. The court had granted an order restraining the defendants from interfering with the peaceful possession and enjoyment of the suit scheduled property by way of an ad interim ex parte temporary injunction till the next date of hearing. When counsel for the petitioner submits that the court ought to have extended the said interim order if the interim injunction is vacated, it would cause lot of hardship to the petitioner. Apart from this, it is submitted by the party in person that she has also sought for several other reliefs before this court in the prayer. She sought the prayer number 2 is to direct the third additional court to execute settlement terms in OP number 1415 of 2021, as it is the first petition between the same parties before proceeding with any other cases between the same parties. To direct the judge, family court, to direct the respondent to submit release deed of the suit scheduled property. To direct the third additional family judge, Bangalore, to mark the petitioner's evidence and related evidence in English. To direct the third additional court, family court, not to precipitate any matters in the absence and affidavit of the petitioner. Allow the petitioner to release the costs of the petition from the defendants and their assets. Basing on these prayers, and the party in person submits that this court may pass direction to the family court as sought by her in the prayer. When counsel appearing for the respondent submits that already you have filed an affidavit.
Yes, ma'am.
That?
Yes, I have filed it.
Stating
that I will not interfere till the
an
pending
affidavit is filed
disposal of
that
the suit.
the respondent will not interfere with the suit scheduled property pending disposal of the petition.
OS number 416 of
Petition.
2022.
Next, having got the counsel party in person, the counsel for the respondent. This court has perused the material on record. The writ petition is filed questioning an order where the court has failed to extend the interim order. In the light of the affidavit that is filed before this court, the interim injunction that is granted by the court is made absolute. Then coming to the other prayers that the party in person is seeking, those prayers are not. This court cannot grant any of the prayers that are sought, and this court is passing the orders exercising the supervisory jurisdiction under Article 227 of the Constitution of India. If there are any if the party in person wants to file any application before the court, she is at liberty to file the applications and seek an order from the court. Disposed of. Accordingly disposed of.
Tell number.
Next.
6.2.
6.2, what is it?
30371.
Yes. What is
This
this
matter was disposed of by Lordship Justice Pradeep Singh Arur.
Yes.
By order dated 17th January 2025. I am producing the copy of the order.
Here it is there. It is there.
Yes.
My lord, there is an order passed
Close.
by the Parliament in CP 400 of 2020.
Hmm?
CP 400 of 2020.
Hmm.
The copy I have filed in this IA
I have the order here.
CP 400.
Writ petition number 30371 of 2024.
In fact, that order is not there because in this IA 25 only I have filed all that order.
Is already disposed.
That is why and all these cases are being left. So to escape my case, that document.
No, that I will see. I am looking at what is the order that is passed earlier. No, before going into this, let me look at what is the impugned order in this writ petition.
My lord, IA 3 I have filed, my lord, kindly
To direct the,
3 of 25.
Please come to your prayer. Come to your prayer in WP number.
Yes, my
uh,
lord. So, there she is asking given by this honorable body. That
Come
is
to
why
the
I
prayer
have-
at page number 30.
My lord, IA I have filed, even though there she is asking given this petition, my IAs are being kept in abeyance. So that improved order I have filed in IA 3 of 25. In this honorable body.
That is a separate action. How can you file in this? You sought for a prayer to direct the third edition of Bangalore to dispose of the matters within 3 months. An order is passed. If that order is not complied with, again you will file another IA in this petition. How can you? It is violation of the orders of the court. That you should say. Isn't it? There is an order already passed and the court has already directed. So if that is, you can't reopen this case again. Yes. Which order? You filed an IA to set aside this order. Why?
My lord, IA 3 of 25. After this.
Why don't you engage a legal aid counsel? Because you are not understanding this. Not another petition. What is this IA? IA 1/25 for modification of the order dated 17/1/2025. Give, so open it. You are saying that she has filed an order to set aside the order. Why are they numbering all this? How is it maintainable? You file to exercise the order dated 17/3/2025 in IA number 2 and to allow for direction for medical examination of the impotency test. How can you file all this? And why the section or numbering all these petitions? How is it maintainable? Ask them to come. Why are they numbering all this? Ask them to come. Well, there should be some logic in it. So what? 14%. So if 14% files anything, they will grant. Ask them. Ask the registrar judicial why all these petitions are numbered like this. There should be some nexus to what is she asking for. You sought for a disposal. Disposal is granted. You want to set aside that order. You want that impotency test.
My lord, I was asking for a modification of the order because there was a directions given within 4 weeks to dispose the order. Again, it is not disposed.
What is IA? What is IA number 2, IA number 3, IA number 4? Set aside the order dated 17/3/25 in IA number 2. What is IA number 2? In lower court IA number 2, can you file an IA before this court? And if you file, why are they numbering it? In the writ petition, where are you are seeking a modification of the order. Your case is, though court has directed to dispose of the matter, the court has not disposed of. That much I can understand. What are all these applications in this?
But that she has filed contempt against the presiding officer of the third additional court.
Then why all these applications here? Call the section, call the concern, 1 minute. Please wait, please wait. Please wait. Call the section people and call the registrar judicial also. Why these kind of applications are numbered? Are they not supposed to see what is the application file? What is the order impugned? What is the order that is say the sought modification for? Is it not wasting court's time with all these applications? That's what I'm saying. The writ petition is filed. Whether it is party in person or an advocate, procedure is one and the same, for everybody. Because party in person comes, every petition will be numbered. They are not using any. The WP number 30371 is filed seeking a direction to the third additional family court judge Bangalore to dispose the matter within 3 months in MC number 3129 of 2023 as a prayer for nullity of marriage, seeking to dispose of the matter within 3 months, and to direct the respondent to pay 1 crore of compensation for mental agony, cheating, and physical abuse. Then a coordinate bench of this court had passed an order on 17th January 2025, had disposed of the matter, observing that it is the grievance of the petitioner that she has filed several applications. The family court shall take into consideration these applications and decide the matter after providing reasonable opportunity to the respondents to find necessary objections and deal with the matter in accordance with law expeditiously without granting unnecessary adjournments to either of the parties. It is needless to mention that family court is at liberty to impose cost, be it exemplary, against any of the parties for unnecessary protraction of the proceedings. After that order is passed, now the party in a person has come up before this court by filing as many as 4 IAs. IA number 1 is filed seeking modification of the order dated 17/1/2025. IA number 2 of 25 is filed seeking, where is IA number 2? How can you file all this here? Why are you not understanding? Why are you wasting the court's time like this without no fresh writ petition? You are wasting your time. You are wasting the court's time with all these kind of applications. IA number 1 is filed. That the order of the High Court, that there is a gross violation of Audi Altram Patrum, violation of the High Court order dated 17/1/2025, and to modify review further directions on order dated 17/1/2025, and to consider the memo dated 6/12/2024 in the interest of justice and equity. Then IA number 2 is filed to set aside the order dated 6/11/24, 17/1/25, and to set aside the order dated 29/11/2024 as there is gross violation of Adi Altram Patrum. Then IA number 3 is filed to set aside the order dated 17/3/2025 in IA number 7 and to allow for permanent alimony and maintenance in the interest of justice and equity. IA number 4 is filed to set aside the order dated 17/3/2025 in IA number 2 and allow for direction for medical examination for the impotency test in the interest of justice and equity. This court is not able to understand why these type of applications are filed, which is beyond the scope of the order, that scope of the prayer that is sought in the original writ petition, and the order that is passed by a coordinate bench of this court is to dispose of the writ petition, dispose of the pending matters expeditiously. And when in that in seeking modification of the order, another 3 IAs are filed, and unfortunately, the registry has numbered all these IAs without even looking into what is the nexus between the prayer that is sought and what are those applications. Can those applications be numbered or not? The party in person who is not aware of the proceedings, without even availing or trying to avail the legal help or from the legal aid, is filing these kind of applications by wasting the court's time with these many IAs and with these many petitions, one after the other. Accordingly, the writ petition, this court reads no reasons to modify the order dated 17/1/2025. Accordingly, all the IAs are dismissed. Next, what is 6.3? What is impugned order? Where is the impugned order?
At
Asking
page
to come,
number
it is right down.
132 of the report.
Huh?
132, my lord. IA number 2 is an application.
132.
Yes, ma'am. 3 IAs she has challenged in one writ petition. IA 2, 6 and 11. 7.
Yes, where is the order? That's what I'll let me look into. Anything that is legal, 100% court will pass an order in your favor. Not on each, any voluminous record you file, that cannot be considered. If your application for interim maintenance is not considered, we will pass an order to directing the court to do it. Let me look at what is the interim order, or impugned order. Page 132 is the impugned order. Oh yes, what it is. In view of the undertaking given by the land advocate by the respondent is directed to produce his bank statement. Which year is this criminal miscellaneous of 2023?
23.
Till now, the IA is not decided?
Because she has filed, IA number 2, my lord, is an application.
Let her say.
Is an application filed by the petitioner under section 125(3) of CRPC with the main petition seeking for allowing the application without specifying the prayer which she is seeking through the said application. The application in IA number 2 filed by the petitioner is dismissed with liberty to file fresh application referring to the relief which she is seeking for. May
do you know what is the procedure for asking for interim maintenance? There needs to be an IA.
Yes.
Did you file an IA? Yes. What is that IA number? What is the IA number? Tell me. Please show where is that IA in these papers. 100 and 1 minute. Let me look at it. So now, where is the prayer?
101 is the IA number.
Now you have filed. This is a petition under 125 CRPC. There should be an IA. Where is the IA?
Page number 108. I have filed with prayer with the court direction. Page number 108.
You understand what is the main prayer? What is the interim prayer? Main prayer is this at 108. During the pendency of the petition, you need to ask for interim maintenance. Where is that IA? I am asking. 100.
101 number.
Let me look at it.
That is the first
Just wait. The court, the judge has rightly said, there are rules of practice here. This is not under section 125, you filed a petition. You should file an IA for interim maintenance. What is the interim maintenance you sought? Your main prayer and interim prayer cannot be one and the same. I will record that you are not able to defend the cases and you're wasting the court's time. You should only be represented by an advocate. Where is the interim prayer? Show. Where is the prayer for the interim maintenance? If you are seeking 1 crore in the main petition, interim petition also 1 crore will not be granted.
Prayer is there in the affidavit section 11, page number 107.
I'm looking at it. For interim monthly maintenance of 5,000 for myself and 50,000 for my respectively to be released, then why the court is not taking it as an application?
That for the reason stated in the accompanying affidavit, the petitioner most humbly prays this honorable court kindly be pleased to allow the application in the interest of justice and equity. That is all what she said, prayed. Then, your lordship, she had to file assets and liabilities, affidavit of assets.
She has not filed.
She, actually, I will take your lordships through what she has done. She was married to the respondent on 8/5/2006. The respondent had purchased a property on
We'll not go
24
into all. We'll not go into all.
No,
that.
no, no.
Court
I
on
will tell you.
technicalities.
She has sold that property in toto and she has taken
That is on the merits of the matter. Court has not considered her interim application. That's what is her grievance now.
Let her file the assets and liabilities.
That's what I'm asking.
Yes.
That's what I'm asking. As
Yes,
per the judgment
the
of
court directed her to.
The written arguments, kindly in the same written arguments is there, my lord. Written arguments, page number 1 to 11.
No, looking at the impugned order, come to the impugned order. Instead of correcting the mistakes, you have come to the court, when you have come to this court in the year 2024 and you are waiting till 2025. Can't you correct it and come up with an appropriate application? By this time, your request would have been cleared by the High Court. Then why did you come here?
She should pursue it there.
The writ petition is filed, questioning the order dated 5/10/2024, wherein it is submitted that her prayer for interim application, her application for interim prayer seeking maintenance was not considered by the court. This court had perused the order passed by the court. I'm not considering her. I'm looking at the order. IA number is an application filed by the petitioner, and the prayer sought for in the application is to summon. IA number 7 is for what?
My lord, IA number 7 is for I have asked.
Someone to produce document, certified copy of back statements of respondent and his mother's, father's, brothers and sister in.
The party in person is not able to understand any of the procedure that is required to be, and unnecessarily she is wasting her time and also the court's time. She is not in a position to assist the court, and in this process she is not able to get her case decided, and she is not in a position to because of the lapses on her part in understanding the procedure. Unnecessarily the court's time is wasted, and she is also not in a position to get the order from the courts. The petitioner is advised she cannot, she can't waste the course time like this. She shall approach the legal services authority, and the legal services authority shall appoint a counsel, shall, shall, shall appoint the counsel, legal aid counsel. Now right from, there are about 5 writ petitions that are before this court. All petitions are for rectification of the office objections, and the applications that IAs that are filed are unknown to law, and it is not expected that the party in person knows all these procedure, and it is very difficult for the court to deal with these kind of cases. She has to be represented by an advocate, hence she shall approach the legal services authority, and the legal services authority shall appoint a counsel for her. Yes. After that, after the counsel is appointed, she can prosecute this WP number 18217 of 2025, which is also coming up for non-compliance of office objections. Yes. Everything, this also 6.3, 6.7 will be clubbed, and you can't appear as a party in person.
That's 7.
After appointment of the counsel by the legal services authority, list WP 2302 of 2025 and WP 18217 of 2025. Inform this to the legal services authority. That is already dismissed. Which one? In first matter also. 34325 of 2025 also shall be listed after the advocate is appointed. Short date. List all these matters, but list all these. You will get a better relief if you have an advocate. Please understand that. I am telling you in your interest. List this matter on 10th of July. By the time the legal services authority shall appoint a counsel for the petitioner. Go to the legal services authority, show her where it is. They will not do all that. They will not do all that. We can't waste course time like this with all these kind of petitions without even understanding what you're doing.
ಅದೇ ಒಂದು ಆರ್ಡರ್ ಇದೆಯಲ್ಲ ಇದು ಕನೆಕ್ಟೆಡ್ ಎಲ್ಲ ಇದೆ. ಮೂರ್ ಮಾತ್ರ ಕನೆಕ್ಟೆಡ್. ಅಲ್ಲ ಮೂರು ಒಟ್ಟಿಗೆ ಕಟ್ಟಲ್ವಾಮ, 2 ಮಾತ್ರ. ಈಗ ಪೋಸ್ಟ್ ಆಗಿರೋದ್ರಲ್ಲಿ 2 ಮಾತ್ರ ಒಟ್ಟಿಗೆ ಕಟ್ಟಿರ್ತೀವಿ. ಇಲ್ಲ ಇದು ಕೊಡಿಲ್ಲ, ಅದು ಕೊಡಿಲ್ಲ, ಅದು ಫೈಲ್ ಮೇನ್ ಫೈಲ್ ಇದು ಒಂದು 2308
ಮೇನ್ ಫೈಲ್ 2302
ಎರಡು ಒಂದು ಕನೆಕ್ಟ್ ಅಷ್ಟೇ. 18 ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲ ಇವಳೆ. 18 ಇಸ್ ಕನೆಕ್ಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ರಲ್ಲ, ಹೌದಾ? ಹಂಗಾದ್ರೆ 13 ಒಟ್ಟಿಗೆ.
ಮತ್ತೆ ಇದು ಐಎಸ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರಲ್ಲ, ಅದು
ಯಾವುದು? ಐಎಸ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದು ಹೋಯ್ತದು, ಡಿಸ್ಪೋಸ್ಡ್.
ಇದು ಅದು
ಡಿಸ್ಪೋಸ್ಡ್ ಮ್ಯಾಟರ್.